It is
Okay.
for admission matter, my lord. I got the relief, my lord. The case basically become infectious.
Sri J.I. Borbhuya Learned Counsel for the petitioners has submitted that during the pendency of the writ petition, the grievances of the petitioners have been redressed. Para. Also heard Sri S.S. Roy Learned State Council. And revenue, anyone for revenue? As Datta is there, Satyajit Datta? Or who is there? Revenue? Is he there?
Yes.
Also heard Sri Bhattacharjee, Learned Standing Council, Revenue Department. Para. Writ petition is accordingly dismissed as infructuous.
May I please, Your Lordship?
Yes.
With the consent of other side, I need to mention item number 8.
8 years.
On behalf of PK Medhi Lordship, some personal difficulties, Lordship, let it become after the vacation.
On behalf of?
PK Medhi, CGC.
Okay, yes.
My lord,
22 matter.
date may be fixed after vacation, my lord. So,
Okay. On a request made on behalf of the learned CGC, matter is adjourned to be listed on 15th of July. Sri D.P. Bora, Learned Counsel for the petitioner, is present.
Your Honor, I beg to mention an item for listed to be tomorrow. I am the petitioner and
New matter,
new matter. Yes.
fresh matter.
Fresh matter.
When did you file?
Yesterday, e-filing yesterday, and
Okay, we'll have it tomorrow.
all.
may I please the lordship, my lord, I beg to mention item number 13, my lord.
1-3.
1-3. I
Okay.
am for the health department,
Hmm.
for the petitioner.
Hmm.
My lord, in this matter, some developments are taking place, my lord, and it will take some time, my lord. So I pray for listing the matter in the next week, my lord.
Next week will be difficult.
Yes.
Next week, motion matter. It's for motion.
Admission.
Admission matter, debarment matter, Lordship, I am not on implaint.
Blacklisting.
Likely.
Oh,
On
the other
Tuesday,
day it had come up.
Lordship.
Tuesday.
Tuesday, my lord.
Okay. On a request made by Sri D.P. Bora, Learned Standing Council Health Department, matter is adjourned to be listed on Tuesday, date to deliver, 23rd.
Yes.
Yes,
Obliged.
Hmm.
Mayor's Lordship. I recommend item number 30 Lordship, admission matter 32 Lordship.
32.
Yes, Lordship. Learned to engage counsel in outside the Assam Lordship. So, feast after vacation Lordship.
25 matter. Who is outside Assam?
Mr. A. Manna Lordship.
Okay. Inform the other side.
Yes, Lordship. Yes.
You have informed here. Okay. On a request made on behalf of Sri A. Manna,
Manna.
Learned Counsel for the petitioner, who is stated to be out of station, matter is adjourned to be listed after the vacation.
Yes, may be given Lordship.
List on, we give 20,
Yes.
20, 27, this tarikh.
Obliged, Lordship.
May I please, Your Lordship, I beg to, with due respect, I beg to mention item number 29. We have missed the item. Can it
Miss
be-
the item. How did you miss the item?
So, names are not shown in the cause list.
Okay, you are for whom?
For respondent number 5, ATPA4.
Okay. You are J. Busha.
Yes, Your Lordship.
Ms. J. Busha, Learned Counsel.
Mr.
Ms. J. Busha, Learned Counsel, appearing on instruction of Sri N.C. Das, Learned Senior Counsel, has submitted that though they appear for the respondent number 5, their names have not been reflected in the cause list. Para, have you informed the other side?
Yes, Your Lordship.
Matter accordingly stands adjourned to be listed on
Vacation,
15th of July.
can it be on 23rd of July?
Okay, not 23rd, 20th of July, 20th of July. Names of the Learned Counsel for the respondent number 5 be reflected in the cause list.
May I appeal, Lordship? Lordship, may I be permitted to move an interlocutory application tomorrow, Lordship? The main matter is listed tomorrow. Obliged, Lordship.
Yeah, please, Your Lordship. I will beg to mention item number 4 with the concern of the other side.
Matter number
4 with the concern of the other side, Lordship.
4 is a old matter.
Yes, Lordship. Due to for some personal difficulties, Lordship.
When can we have? 18 matter,
It-
normally we do not adjourn 18 matters.
Lordship, immediately after vacation.
After vacation,
Yes, Lordship.
difficult, madam. Why are you seeking time? 18 matter.
Due to some personal difficulties, Lordship.
Yes, Mr. You are for the Numuligar? Okay. A request for adjournment has been made on behalf of the petitioner. However, uh, noticing that the matter is of the year 2018, this court has reluctantly acceded to the said request. List, matter accordingly stands adjourned to be listed on the reopening itself, 13/7. But no adjournment on 13/7.
Okay. Authorized, Lordship. May I please, Your Lordship, I beg to mention item number 26, Your Lordship.
26.
Yes. Your Lordship, the engaged senior counsel is out of session due to some personal difficulties, Your Lordship.
These are also old matters, 18 matters.
Yes.
When will you be back?
Next, Your Lordship.
Next week.
Yes.
So we'll have it on Tuesday next. Okay. On a request made on behalf of Sri A.K. Purkastal as the senior counsel for the petitioners, matters are adjourned to be listed on Tuesday next. Tuesday hole 23rd. This will be item number
26.
26. Which, okay.
Item 1 and 2.
Look, the government was directed to obtain the, produce the records, Mila.
Yes. What is there in the record?
All these documents, whatever we have annexed in the petition, in our affidavit in opposition is there, my lord, providing the justification and all. And lordships wanted to see the, my lord, financial bit as well as technical bit of the first tender. But that has nothing to do with the present case because we have held the petitioner to be L1 as well as technical.
No, we wanted to know from which stage this new thinking has arisen.
Yes.
Yes, my lord, after it has arisen after, my lord, it was forwarded to the government for final approval.
Government means
Sir, to the, my lord,
department.
Yes, department. In 24, where, my lord, it will be flag mark F. No, D, my lord, sorry, 2611, yes.
I mean, L1 কেতিয়া হবে?
Not 2611.
D.
Yes, ma'am. D. Down below, my lord, start from the left side. Black one.
7-1
After,
হতে হবে?
yes.
7-1.
Yes, D. Yes, what is D? Hmm.
গভর্নমেন্টক পঠাব কিবা ৰিকুৱাৰমেণ্ট আছে নেকি? গভৰ্নমেন্টক পঠাব কিবা ৰিকুৱাৰমেণ্ট আছে নেকি? গভৰ্নমেন্টক পঠিওৱা কোন কুইজ কে আছে?
2412, my lord. Yeah. One letter is there, my lord, just prior to, my lord, this agenda note.
24.
Well,
By whom?
before this, my lord, documented D, my lord. This has been issued by the superintending engineer to the chief engineer, my lord.
এইটো
Documents
কোন
found in
তাৰিখে?
agenda note, my lord. Everything is there in the agenda note.
11-12 নেকি?
25 technical petition.
নহয় বিকাশ শৰ্মা কোন?
বিকাশ শৰ্মা হেৰি বেলেগ এটা
এখন কি দিলে?
এইটো নহয় বেলেগ এটা কাম যে অলৰেডি এলৱে দিছে
We have found the 26/11/25.
That is the one document.
26/11/25.
Yes, it was forwarded to the government.
Yes.
Along with all the, my lord, financial bit, technical bit,
Hmm.
agenda note, everything was forwarded.
Then where is the decision of the government?
Then, my lord, my lord, new all these complaints and all came, my lord, either from the public as well as the local MLA. And, my lord, a revised estimate was called for. Lords, you will find that, my lord, from FGH. And I also, my lord. FGHI. Which we have annexed in our, my lord, affidavit also, that report and all.
নহয় নহয় যিটো 7 তাৰিখটো ক'ত পালি 7 copy of the order order financial bit কোন তাৰিখে খুলিলে আমি page 29 আমি যে তাৰিখ নাই তাতে
26/11.
Which flag?
My lord, FGHNI. These are, my lord, the volume and all, my lord, all estimate reports, my lord. Revised estimate,
No, that is okay. Now we want to see the decision.
my lord.
what prompted what triggered
What is where is the decision?
Well, in the office note, my lord, they have, but here, my lord, what the engineers, they say that, my lord, since it's an online tender process, my lord, only the 1 or 2 notes are there. That apart, my lord, whatever documents have been received, my lord, from the higher authority and whatever documents have been, my lord, forwarded, all has been recorded there. Yes, in the last note, lords, we will find that, my lord, it was directed to go for press after considering the estimates and all.
high-handed killing there.
We are more interested in the decision-making process, the office notes, not the communication as instructed on draft consideration.
end of the day my lord the employer must record a satisfaction and that must be based on some objective material
And in that case, probably, my lord, it will have to be from the government also, because, my lord, by flag mark I, the revised estimate was subsequently approved by the government on 11/2/2026 and tender was plotted on 12/6/12/20. That document, lords, you may see I.
No, the decision does not reflect here in this file.
Decision, my lord,
Till 26/11, there is an office note
yes,
that everything was sent to the government till that, 26/11.
yes,
Thereafter,
as instructed, some that, my lord, noting.
now,
that here.
from where did it originate, this whole concept on the bona fide aspect, we are not saying anything.
Yes.
But how did it originate that there has to be a change of plan because of this reason? Who thought about it? We want to have that file.
Yeah.
This is not the file.
See the file of the government also. my
That is
lord,
what we had
yeah,
indicated on the last occasion.
No, I thought that it will be there.
No, there cannot be a
Yesterday
different
evening,
file. Can there be a different
Yes,
file?
my lord, the engineers, my lord, chief engineer's office, this is the file, my lord, which they have processed. Probably another file, of course, will be there in the government office, my lord.
You have obtained that,
Probably I will have to, my lord.
Okay.
Final
let
note
that
will
let that be produced. That will clarify everything. Here note sheet is not absolutely nothing. We are more interested in the note sheets.
Lots of-
How did it originate?
No, my lord, if that is the understanding of the department that these are the only records, then it's a disaster.
No.
That cannot be. There has to be some
No,
movement of files.
Final
And note sheets.
approval was given by the government on, my lord.
Okay.
11.
No, my lord, whether there is any requirement of for once the tenders are, my lord, somebody is adjusted as L1. I don't think there is any requirement of forwarding it to
In all
government.
cases, government approval is required.
No, my
So
lord,
where the
but if
PWD
the
is
government
concerned-
approval is required, then something.
Ultimately, who allows the work?
Chief engineer.
But, my lord, finally, before allotment, my lord, it is forwarded to the.
That aspect also we'll
That's the
see, but,
procedure in every case, not in this
No, my lord,
particular.
no, I'm not disputing that. What I'm saying is which clause in the tender or which is the scheme which requires, no, that has to be there.
How the files will be moved, my, that is not there.
No, it's not a question. No, how files will be moved for that rules of executive business is there. But that there is a requirement.
let him play
Yes.
or have the.
Yes.
Okay. Heard Sri K. Chaudhary runs Senior Counsel, assisted by Sri S. Hoff for the petitioner. Also heard Sri B. Gugoi, learned AAG, representing the Public Works Department. Full stop. Para. by the last order dated 15/6/2026. This court had directed production of the records of the entire tender, starting from the process of floating of the initial tender till the later decision, which is impugned in the present writ proceeding. Para? Pursuant thereto, comma, the learned AG has produced a file number CE/DEV/ASOM MALA 3.0/48/2025-26. Full stop. Though cursory perusal of these documents contained in the file would, however, not reveal as to how and when the new thinking and decision had emanated, for which the cause of action has arisen. Para? Sri Gogoi, the learned AG, at this stage, prays for some more time to produce the records which are with the government. Correct? Para? When? Tuesday?
Tuesday, yes, sir.
Tuesday.
Could it be Wednesday?
Okay, Wednesday. As paid for, list on Wednesday for production of the entire record.
Diploma.
Tomato naam to side lo. Eight number ke side. This you are handing it. Yes, the records produced today are handed over back to the learned AG. Ito ikhine number to halke bar side lo. Photo mari lo. Mo this you number to photo mari lo. Mr. Bhuyan, you take back the records.
Please, your lordship. Lordship, my senior, Mr. B. Chakrabarti, is on legs, my lord. Matter may be passed over for time being, my lord.
Yes, time being, we'll have it because it's an old matter.
Yes, my lord. For time being only.
I pray for some time, Lordship.
Time on behalf of whom?
Mr. H. Buraguha, his father is.
On the earlier occasion also, they have taken time, my lord.
Okay, sir. This is for medical reasons. We'll have it sometime. Next week, is it okay? Next week? Okay. A prayer for adjournment has been made on behalf of Sri H. Buraguha, Learned Council, on medical grounds in the family. Para? In view of the above, matter is adjourned to be listed on Wednesday next.
I'm highly obliged.
Wednesday will be which date? 24. Item 5. Item 5. The Google?
The IIT authority yesterday filed an affidavit loss. That is not in record loss.
You have filed an affidavit on behalf of the IIT, not on records. What is the matter about?
Issue is the lawsuit that petitioners are working in the IIT guest house and they are outsourced, and the respondent is their employer.
Let the affidavit be tagged with the record. When can we have?
Any date,
Huh?
any date otherwise.
So next week we not unless and until it's very urgent. Next week we'll not have. We'll have it after
vacation.
Okay. Would you like to file any rejoinder?
I am unable to contact the petitioner for long period. That is another issue.
Heard 3 NJ Gogoi, Learned Concept for the petitioner. Also heard 3 AD Day, Learned Council for the IIT, as well as 3 D Day, Learned Council for the Respondent 4. Para 3 AB Day, the Learned Council for the IIT, has informed that affidavit in opposition has been filed yesterday, which however is not tagged with the records. Para? Let the affidavit be tagged with the records and the matter be listed on 22nd of July.
24th, my lord.
24th of July. What about your affidavit, Mr. Day?
As per affidavit lordship, IIT.
Further pleadings may be exchanged by the next date.
Lordship.
May please, Lordship. Lordship, instruction received verbally, Lordship, they have stated that on 4/6/2026, Lordship, the amount of rupees 3,73,719 rupees has been sent to the finance department, Lordship. Here is to finance is not a party, Lordship.
Contextual bill,
No, Lordship, salary encashment.
salary encashment.
Lordship, I retired in 2019. Since then, Lordship.
When did you, Mr. Chakraborty, when did you send?
Lordship, will see the last order.
For June, Lordship, they have sent to the finance department, Lordship.
Every time, Lordship, this type of plea is taken by the
Lordship.
Lordship, please to see the last order, particularly order date 73/2026, paragraph 6.
No, 4th June, it has been sent.
Lordship.
There is some development, concrete development, 4th June. Let us give him a chance.
And a sanction amount of rupees.
Is anyone there from this finance department? You are for finance department. It's not a party here. Mr. Bhuya, though you are not a party, just try to get some instructions in this.
Just take a.
He'll give you the information. Heard Sri Asika Leonard Senior Counsel, assisted by Sri K. Jain for the petitioners. Para? Sri A. Chakraborty,
Respond number
Leonard
one.
Counsel for the respondent number 3, 1,
1 and 3 notes.
has submitted, 1 and 3, respondent numbers 1 and 3 has submitted that that he has received oral instructions as per which on 4/6/2026 the matter has been sent, the proposal has been sent to the finance department. Para? Do the also heard miss? What is your name? This on behalf of? Also heard Miss D. Das, Learned Counsel for the respondent numbers.
Lordship, I'm 3 notes.
You're
Sorry.
3 then.
Only
Amita
three
A.
notes.
Chakraborty all 3, huh?
Only 3 notes.
3, 1 and 2.
Only 3.
Though the finance department is not a party, comma, this court has requested Sri M. Bhuya, Learned Counsel who appears for the finance department, to obtain instructions and the status of the proposal. Full stop. Sri Chakraborty, the General State Counsel, shall furnish the necessary information to Sri Bhuya along with the relevant documents during the course of the day. Para? List on when can we have the information, just we have it before the vacation. If it's possible, then I'll have it on 16th, not 16th, 25th of, okay, 25th of June. If you seek time, we'll grant you time, but try to get the information.
So then,
In item 7, my lord, yesterday I had Thakur adjournment film, my lord.
7 is a old matter, Mr.
Lord,
Botaku. Why are you seeking time?
Today, only for today, my lord, if possible next week, my lord. Some difficulty.
You are seeking on behalf of Mr. Botaku.
No, Lord.
Okay, when do you want?
Next week will be my lord, motion develop, then after vacation.
21 matter.
Lord.
On a request made on behalf of Sri S. Botaku, Learned Senior Counsel for the petitioner, matter is adjourned to be listed on we'll have it on 15th of July.
15th July. Deeply blessed.
until time.
Item 9. Where are your friends?
Not in this court.
Okay. None appears for the petitioner on call, whereas Ms. B. Sharma, Learned CGC, is present. Para? In the interest of justice, matter is adjourned to be listed on 13th of July, 2026.
Item 10.
Item 10, Mr. Pathak,
Yes,
what is
Chief.
this?
In this method, the respondents are yet to file.
I'll seek some time to file our affidavit.
22 matter, Mr. Munir, why are you seeking time?
My name was not reflected, my lord. Only the previous or by previous order, the name has been reflected, my lord.
Okay, Hearts Free N. Pathak, learned counsel for the petitioner. Para? Munir, the learned counsel, standing counsel.
2, 3, and 4.
Assam Khadi and Village Industries Board, within bracket respondent numbers 2, 3, and 4, has however submitted that the brief is being handled by him subsequently and accordingly placed for some time. Para? Considering the above, as well as the fact that the matter is pending since the year 2022, a short accommodation is granted to enable Sri Munir to have the instructions and oblique or file affidavit in opposition. Para? List on, we'll have it on 15th of July. You file it before that.
28.
Oh? 20, okay, 20. 20 July.
Give the option.
Yes, Mr. Das.
Instruction I say. Already terminated, my lord. Terminated from my work. And that's my lord. Was the
Affidavit
instruction has
filed.
been-
Mr. Bhuya?
Also, we have received some instructions regarding the progress of work which has been done by the private petitioner, RB.
I have filed your affidavit.
Well, this is, no, this is to file. They have to file it.
You filed the affidavit?
I'll give a reply to it.
Okay, okay. Heard Sri D. Das, learned senior counsel, assisted by Sri P. Sharma for the petitioner. Para. Also heard Sri M. Bhuya, learned counsel representing the Public Works Department. Para. Sri Bhuya, the learned counsel has submitted that instructions have been received and he prays for time to file the affidavit in opposition. Para. Matter is accordingly adjourned to be listed on 17th of July. 17th. If you require time, we'll
I'll
continue.
file it, I'll file it.
No, it depends when he will file.
Yes, yes, correct.
If he files on 17, you file it before 17th.
Clear.
Is there any interim order, Mr. Das? No.
No. No, there is already an interim order that is protected with not risk and cost.
Okay.
Yes, I'm not.
Item number 12. Yes, Madam Chaudhary.
Yes, my lord, I have received some instruction which is not gonna complete. So I'm seeking a small.
What is the matter, Madam Chaudhary?
Non-payment of bills.
Non-payment of
Bills.
bill, lordship, and page 13 is the liability statement, lordship. May
Okay.
kindly pay.
You get the instructions. Let her have the instructions. Heard Miss K.K. Chaudhary, learned counsel for the petitioner. Para. Also heard Miss P. Chakraborty, learned counsel for the,
3, 4, 5, and 6.
whom are you representing? Whom are you representing? Water Resource. Understanding Council Water Resource Department, who prays for some time to obtain the complete instructions. Sri S. Kakoti appears for the respondent numbers 1 and 2. Para?
Let them also take instruction because our instruction is that we have not received funds from them.
Okay. Let instructions be obtained by the learned counsel for the respondents. Full stop. Let this matter be listed on 15th of July. You get the instructions.
Please.
30-31 supply list.
Yes, ma'am.
R. Dubey. Where is Mr. Dubey? Last occasion, I think. Mr. Dubey. We can take it for disposal.
Yes, yes. In fact, these are all covered matters, both.
Mr. Singh, covered matters.
Not exactly, my lord. They are.
That means covered. Not exactly means covered. If you say no, then not covered. Not exactly means covered. So if it's covered, why should we devote time?
My lord, have a judgment.
Which one?
If you want your submissions to be recorded, it is not covered, we'll record your submission is not covered.
It is not covered, my lord.
Not covered.
My lord, may have
Why?
it the judgment.
Why it is not covered? Facts are
One
different.
one
Issue is
judgment
different.
which went up to the Supreme Court, Honorable Supreme Court has stated that it should not be treated as precedent. What there is your honorable court's judgment is there that has been kept in abeyance by our division bench, my lord. So in that context, I'm saying that it's not covered, let it be built independently, my lord.
In fact, taking note of that Supreme Court judgment, this writ petition was disposed of. They went into appeal, my lord. That appeal was also dismissed. 66. But in this judgment, that what my learned friend is referring to, earlier judgment has been considered. And since it was not a precedence, therefore their lordship has not taken as a precedent that judgment. So it's an independent exercise of lord.
Yes, we remember. We had done some Anup, I think Anup case.
Anup is the second one, my lord.
Second.
This is little different, which is covered by this WPC number 66.
Sir, but if we have applied our mind, you may say that it's not covered by the earlier, but we had applied our independent mind not treating the earlier judgment as a precedent. Independently, we have held it, he'll be entitled. The distance factor.
Yes, yes.
These
Let two aspects.
These two matter has been tagged on my prayer because they cannot approbate and reprobate, my lord. In one case, the distance has been lowered, my lord, lesser distance, and in the other case, there is a little bit of higher distance. So he cannot.
Same route.
No, different route. In one case, they have come up for because the distance were higher. Now, in the another case where we have recovered the money because of the distance is lesser, they have come up. The first case is that one, my lord.
If it's possible today, we have it, or otherwise.
After vacation, my lord, because division bench, our judgment will also come up, my lord.
When is it fixed? Do you have the judgment?
Yes, yes.
The second one?
Second one I
of this
have.
court?
In fact, your lordship has passed that order.
Oh, we have, we remember.
Yes, yes.
Who was the counsel? A. Borbora, A.C. Borbora.
My friend was.
No, the other one, Sahiwala was the counsel, I think.
Yes.
Mr. Singh, Sahiwala was the counsel.
Sahiwala was the counsel in the writ petition number 2002.
Where we had said that
That is
without
pending
being.
before the division bench.
This is first one.
It's pending.
Pending now. Judgment has been kept in abeyance, and this one, 66, I can distinguish that 66, my lord.
Well, there are two cases before your lordships.
At my lord, this 66, which my friend is referring, my lord, in that case, the facts is different, my lord. Because after the NDC was received, after the NDC was accepted by the Food Corporation of India, my lord, and the Food Corporation of India recovered the money after long 7 years, my lord. Only on that ground it was interfered, my lord. My humble submission is that, man, this judgment will not cover.
What has happened to this Anup decision?
My lord, this will come up for final hearing on 5th of August, my lord, and the
5th of August.
Judgment has been kept in abeyance.
But may I indicate one aspect? But these two cases that's before your lordships are on two different facts. Both are covered by separate judgments. But so far as this item is concerned, first one, But here the case was after I have executed the contract, that is over, then they wanted to recover amount, which your lordship has held.
On the ground of distance,
Yes, on the ground of
that
distance.
the distance which was
Now-
projected is
Yes, in the subsequent tender for which they are going to make an assessment, now they have found out that distance is different. So I had already executed the contract, payment had been made, to say they have retained my security deposit. That WPC 66, which I gave to your lordship's lords, that settled that issue. And against that, they have gone into appeal. In writ appeal, my lord, 159, that has also been dismissed. Now, my lord, considering both the single judge has taken note of the earlier round of litigation where the matter went up to apex court. There, the lordship has said that it should not be treated as precedent. So it was a new exercise, my lords. And against this judgment, my lord, they have not gone. So far as other cases concerned, that is covered by your lordship judgment. This is during the pendency of the contract. When we were awarded the contract, my lord, on the first time, my lord, when we transported it, it came to our notice that their distance is more. Then we submitted a representation. So these judgments are on different footings. There has been cases, my lord, your lordship has also relied upon earlier round of litigations where, my lord, your lordship has held that they are entitled for the longer distance, and, my lord, payment has also been made. There are also, my lord, orders by the review committee.
Mr. Singh, after execution of the contract, how do you revisit? Only because in a new tender process, you found that the distance would be less. See, a subsequent route work in a subsequent period, we do not know what would be the routes, what is the development. But that was the route was finalized by you. Distance was finalized by you. Unless you make out a case of malafide on part of your officers, that is inflated. Some 10 kilometers are made 100 kilometers, then yes. But if 10 kilometers has been made 9 kilometers, we are not going to, after execution of the work.
In this case, my lord, while the work was being executed, then only we have recovered that amount, my lord.
No, how did you recover? See, from A to B, you have stipulated the distance after physical verification. Now, after execution of the work, how can you say that A to B distance is less what was projected in the tender? It's your tender. Unless there is some gross mistake or malafide involved, inflation. See, the dispute is not with regard to short supply or no supply.
No, only the regard.
The dispute is only with regard to the amount which he is entitled to for transportation. You have stipulated the distance. He has supplied. After supply, can you say the distance was not there, it was less, so we are going to pay you less?
My humble submission that while the work was being executed, then the FCI being realized that.
How did you realize?
When we were sorting out for the next tender, then we got the actual distance married.
Difficult. What is the difference?
First, the difference is
Original was 315.48 kilometers, and they have divided it to 295.
295.
57, original was 300?
15.48.
15.
Yes.
And
So
around
there is
20 kilometers.
Around 20 kilometers.
Difficult.
The next one, my lord, there was a distance of
11.41 kilometers. Oh, no, right.
11 kilometers.
11 kilometers.
The difference.
No, my lord, original distance was 11, but it is found to be a bit higher.
13.4 kilometers.
So what is the implication?
Take the benefit of both the cases.
There are judgments covering both these cases. Facts are different.
I will distinguish my lord.
My friend has appeared.
After vacation, my lord.
Okay, we'll have it after the vacation. Come. Okay. Third, Sri R. Dubey, Learned Counsel for the petitioners, as well as Sri B.K. Singh, Learned Counsel for the FCI. While Pre Dubey, the learned counsel for the petitioner has submitted that the issue would be covered by earlier judgments of this court, the said proposition has however been disputed by Sri Singh. The matters would accordingly require deliberations. List for admission hearing on 21st of July, Tuesday. We'll try to sort it out. On which date, an endeavor would be made to finally dispose of the matters. Pleadings otherwise are.
Yes, yes.
Okay.
Because of the facts, I need not file reply, my lord. It's an
In the
admitted.
second case of the MTF need to be brought in record, my lord. I will file one additional affidavit, bringing on the agreement between the parties.
You can produce it just like that. His
Yes, yes.
agreement he'll not dispute.
No, I'll not. Deeply.
And if you think that it needs to be on record, by way of an affidavit, you can file it. By the next date, the FCI may bring on record the agreement by way of an affidavit, if so advised.
Second case, 31.
In the WPC, second to the so far as WPC so is concerned, the land council will be at liberty, to okay.
Deeply.
May it please your lordships.
Yes.
Lordships, I am instructed to withdraw the writ petition. Lordship.
Is it? Okay, item number
15.
15. Sri R. Sharma, learned counsel for the petitioner, has submitted that he has instructions not to press the writ petition. Full stop. Also heard Sri H. Sharma, learned state counsel. Sri J. Hendrik, learned standing counsel revenue department, and Sri name C. Paul, appearing on instruction of Sri K.P. Bhatak for the APDC. Writ petition is accordingly dismissed as not pressed.
Interim order passed earlier.
Interim order passed earlier stands vacated.
I love.
Item 16.
In this matter, my lord, this matter was substantially heard by my lord Justice Mojumdar on 19/5/2026. 19/5/2026, my lord, my part was over, and response of the department
Who was for the department?
Mr. Chaudhary is there, my lord.
Yes, what do you say?
Worship, in our affidavit, certain facts have not been properly clarified because in the.
No, it's on the hearing part, on the submission of Mr. Das. We can send it back to that court, okay? There is a joint submission that the matter has been was substantially heard by a coordinate bench within bracket Honorable Justice R. Majumdar on 19/5/2026. In the interest of justice, let the matter be placed before the said bench for conclusion of the hearing.
Much obliged.
We will not say anything. We do not know how the bench is placed now.
Fine.
14 matter, probably we don't know.
Fine. Deeply.
17.
Who's for the petitioner? I say kya? I say kya? Normally he's there. Where is Mr. Sakya? You said that you'll be taking adjournment. Why? Why are you seeking adjournment? 16 matter. Okay, medical emergency, exceptionally. Yes. A prayer for adjournment has been made on behalf of Sri R.K.D. Chaudhary, learned Deputy SGA, on medical emergency. Considering the above, request for adjournment is granted. Full stop. As the matter is of the year 2016, The same is directed to be listed immediately after the vacation on 13/7/2026. Yes, Mr. Chakraborty, what is this?
Lordship. This matter, we have challenged the penalty order as well as the order passed by the appellate authority, Lordship.
In a departmental proceeding?
departmental
Yes, who's for the other side?
Standing counsel IOC and Mr. K. Kalita appears generally.
IOC.
Lordship.
Where is Mr. Kalisa? This matter will take it up for disposal.
Lordship.
DP pending since 2016. Yes, Mr. Sharma, your matter.
Lordship, actually, he's on Lexington court number 10.
Who?
Lordship. K. Kalita, Lordship. You are supposed to appear in this matter.
Or ask him to come. We'll have this matter today.
Yes, sir.
For the time being.
Lordship.
Hello.
Right.
Until 19 and 20.
Two matters, two matters. Which one will have first?
My lord, Lordship may take up 18, my lord, 18/2017. Very short matter, my lord. What happens in this case?
Short
all-
matter, but the brief appears to be very heavy. Short matter, right?
My lord, what happens in this case? All the petitioners in this case were one point of time employees of the Silchar Municipal Board. All of them have retired in between 2011 to 2013, my lord. My lord, since they are regular employee of the Silchar Municipal Board, they used to get the salary directly from the Silchar Municipal Board, and as per section 50 of the Assam Panchayat Act, Municipal Act, my lord, that is the duty, responsibility of the Silchar Municipal Board to pay the salaries, etc. to them. My lord, what happens in this case? My lord, 2011, a resolution was taken. Lordship may kindly come to page 42.
42.
42, my lord. Next are 542. Resolution was taken. That is resolution number 8. To give the benefit of ROP 2010 to all the staffs of the Silchar Municipal Board. So since at the relevant point of time, all of them were in staff as per the ROP 2010, my lord, and the benefits is calculated with effect from 1/1/2006. So since all of them were at the relevant point of time working under the Silchar Municipal Board, so they are claiming the benefits. They are claiming the benefits, especially, my lord, this is the gratuity and unutilized leave salary. So petitioners were claiming the benefits.
Gratuity and unutilized leave.
Gratuity and unutilized leave salary. Thereafter, my lord, they have filed before this honorable court cases, my lord. First case was, my lord, that is the order 46. Sorry, page 46, my lord, order dated 8/2016. In the said case, my lord, direction was to consider the
They had come before this court earlier.
earlier.
Page
It is
40.
Page 47 is the operative part of the order, my lord. Last paragraph. May I read the paragraph, my lord? Having regard to the limited prayer made
This writ petition stands disposed of with a direction to the respondent number 3 to consider and dispose of the representation dated within a period of 4 weeks from today. That representation was paying for the benefits as per the ROP 2010, my lord. Thereafter, my lord,
Yes.
thereafter, my lord, the Silchar Municipal Board informed the petitioner number 1 here in this case that Lordship may kindly come to page 50, my lord.
Page
Page 50, my lord.
15.
50.
50.
50, my lord.
So what is the second case? At
Well-
page 48? IA.
That is
Oh, it's a correction.
correction. my lord.
Okay.
50.
And what is 50?
50. That is the letter issued by the Chairman Silchar Municipal Board dated 18 May 2016. By that said letter, my lord, the petitioner number 1 was petitioner number 1 and others, my lord, were informed that may I read the letter, my lord?
Please.
My lord, there is a letter to the Indrajit Dattosudri and 32 others. Sir, with reference to the subject cited above, I am to inform you all that from the year 2008-2009, the Government of Assam released municipal employees' salary as pre-revised scales and sanctioned revised scale with effect from 1/4/2014. As per GOP instruction, the Silchar Municipal Board disbursed salary as revised scale as per ROP. That's sir, those employees who are in existing service even after 1/4/2014 in their cases, revised scale of pay, etc. are allowable as per instruction of Government of Assam. That's sir, as per your submitted letter dated 28/3/2016, mentioned that those municipal employees who are in service for the period from 1/1/2006 to 31/3/2014, they will get the benefit like gratuity, leave salary, etc. as revised scale of pay as per ROP. That's the Silchar Municipal Board. Silchar acknowledge the same, man. But the Government of Assam is not yet given effect to the revised scale of pay scale to the municipal staffs. While Government of Assam will give the effect of the same, the Silchar Municipal Board, Silchar, will demand the area, gratuity, leave salary, etc. to the GOP as per your submitted petition under reference. This is the cause of action, madam. They have stated that as and when the GOP will give the benefit
Funds.
fund, then only we will pay. This is the issue before this honorable court, my lord. Thereafter, my lord, another writ petition was filed before this honorable court.
Yes, which one?
That is, my lord, page 54.
54.
54.
Yes.
Lordship got it, my lord. This is another order, my lord, almost similar like others, similar like earlier order, my lord. Operative part of the last paragraph, having regard to the limited period, again, petitioners applied for, pays for giving the benefits, submitting representations, my lord. And hereafter, my lord, the honorable court, considering the prayer, directed to consider the representation dated 28/3/2016 within a period of 4 weeks. That is the Second order, my lord.
Okay.
Subsequently, my lord, some errors are there, that is why correction is there, my lord. Then Lordship may kindly come to page 58.
5-8.
Oh, 58, my lord. The order of the Honorable Court was forwarded to the authority, and again, petitioner number 1 was informed by the Chairman Silchar Municipal Board that a claim of gratuity and leave salary revised scale of pay cannot be granted with effect from 1/1/2006. That is the as per the ROP, the calculation of scale of pay is with effect from 1/1/2006. If the last line, Lordship may kindly see, if the government provides fund for the period 1/1/2006 to 31/3/2014, we shall have no objection in payment. So again, the same reply forwarded to the petitioner. Then Lordship may kindly come to page 68. That is the affidavit filed by Joint Secretary to the Government of Assam Urban Development Department. Paragraph 3 of the said affidavit is relevant, my lord. That may I read, my lord. Paragraph 3. That with regard to the statements made in paragraph 4 of the writ petition, the deponent begs to state that the service condition of employees of municipal board, town committee, and the power to determine the size of establishment has been vested with the concerned municipal board. Moreover, municipal board, town committee are elected autonomous
But
body.
your payments and everything are made from the funds generated by the
Municipal board.
municipal company.
Even, my lord, from 2008 onwards.
So how do you seek a benefit of the ROP?
No, because of this, my lord, resolution. Because of this resolution has taken already, my lord, on 29/8/2011, my lord.
Where is the resolution?
My lord.
Where is the resolution?
Page 42, my lord.
42.
Page 42, my lord.
Please take us to that. You have not taken us to that 42.
Page 42, my lord. Is the English translated?
You have not taken us to.
My lord.
Please, this should be the main.
I'm sorry, my lord.
This is the main.
That is the main issue, my lord. On the basis of this, my lord, our claims are.
42. What is
42, my lord. Resolution number 8, my lord.
Dated
29/8/2011. The English translated copy, madam. And page 44 is the
resolution 8.
Resolution 8, my lord.
What has been stated?
Order that is the
what has been stated?
29/8/2011.
Please read the resolution.
My lord.
Please read the resolution.
My lord. I'm sorry, my lord. Resolution number 8, Government of Assam by its notification dated so and so reconstituted the pay structures of the employees of the state. Employees of the Silchar Municipal Board have been enjoying the scale and allowances as per the state government employees since 1974. The drain laborer sweepers of the Silchar Municipal Board though have been enjoying the pay scale, but still it is not at par with the scale of pay and allowances as per the government employees, for which there arose discrimination in the case of reconstitution of the pay scale. In view of keeping parity for the all municipal employees of the state, a study committee has been constituted. The government of Assam, following amendment of section 50 of the Assam Municipal Act, is going to consider staffing pattern and related bylaws that will binding of the post of Silchar Municipal Board. Abiding by the direction of the aforesaid staffing pattern and study committee, the Silchar Municipal Board resolved to pay the allowances of the Silchar Municipal employees as per Assam Services Revision of Pay Rules 2010. It is also resolved that the drain laborers and sweepers working under Silchar Municipal Board will get the minimum scale of pay so and so, along with grade pay of rupees 1,500. This is the only resolution, and on the basis of this, our claim is there. Ultimately, Silchar Municipal Board said that as and when fund will be received from the government, will give you. The government has in their affidavit stated that no, it is the duty of the municipal board
to generate their own funds.
Fund. And my lord, what happens? I'll show lordship that devolution fund used to be given by the government of Assam from the untied fund, my lord, as a revenue gap to the municipal employees, salaries of the municipal employees as well as other jobs, my lord. So that is also constituting the municipal fund, and the Silchar Municipal Board can give the benefits from the entire fund, my lord. Lordship, I'll come to the their own affidavit, my lord. They have admitted how much we are entitled to. Lordship may kindly come to page 111. 111. That is the additional.
Clarify, my lord, we did not admit that part. The honorable court wanted to. If they are to get that amount, what will be the quantum? So that way we have just apprised the honorable court.
The figures you had worked out.
Yes.
That
It was
that
not an admission. My lord, as your lordship understand.
yes, Mr. Goswami.
But language shows that they have
But
admitted.
two questions will arise, Mr. Sharma. Will the resolution of the municipal board bind the government? Number one.
Yes, bind the government.
Bind the government. Will it bind the government? Now, this resolution was no doubt taken for the benefit of the employees, to give them benefit of the ROP from a particular date, because the state government employees were getting the benefit and your duties were seen to be at par with the state government employees.
Right.
So, in good faith, the resolution was adopted by the board. But the board is a the finance is self-created. They generate their own finance.
It is generated by them. Or
There are grants in aid by the government.
Grant in aid by
But
the government.
generally, funds are generated by the is by own source.
Own source, man.
So now, whether this resolution to give them a benefit of ROP would bind the government to the extent that you have to fund it. That's the question. Whether it will be something which is
My lord, what happens, my lord? We are entitled
if
to.
they pay nothing like that. But is it enforceable?
That's the precise question.
Can you enforce it in a court of law? And ROP is also not a product of the board. ROP is
not
by the different authority. They adopt the ROP and said that we'll give them benefit, but there is no funds. So what do you do?
Since existing employees are getting the benefits, my lord, so we are also entitled to that. At a relevant point of time, we are working as per the ROP, my lord, given the benefit as per ROP.
The existing employees are getting the benefit.
Yes, my lord. They're getting benefits. They have said that.
That's from 1/10/2014.
They are giving, they are saying that government is giving the benefit from 1/10/2014. But my lord, there is no such order passed by the government. Government in their affidavit again and again saying that.
When did you retire, Mr. Sharma?
My lord,
how many of you are there?
total in this writ petition, my lord, is 6, my lord.
6 petitioners.
6 out of that, my lord, already 3 of them died, my lord. 3 of them, that is why, my lord, the second writ petition
They
is there.
retired between 2010 and 2013 March.
In between 2000, petitioner number 1 retired in 2010, my lord. Petitioner number 2 retired in 2013, 3 in 2011, 4 in 2000.
Mr. Datta has given the figures 2010 to March 2013.
Yes, 2000.
Your petitioners had retired. Now, out of the 6 petitioners, 3 have passed away, 3 expired. And why is the second writ petition?
Second writ petition is, my lord, already by only 4 petitioners, my lord.
There
The
are-
same cause of action, my lord. Same cause of
But
action.
petition number 1 is the same?
Petition number 1 is same.
Not required, actually.
Actually, I am the third counsel, my lord.
Now, how do you resolve this?
So, question is this, my lord, that government is again and again giving the affidavit, and their affidavit stated that it is the duty
Yes,
of the.
Mr. Goswami, what do you say? Your stand will be very crucial. We'll hear Mr. Datta after Mr. Goswami. Mr. Datta,
Yes.
we'll hear you after him.
Yes. Kindly see that affidavit filed with the government, the additional affidavit running.
In which one? 18?
Yes, yes. In
WBC 18?
Yes, case number 18. WBC 18.
Affidavit by?
But by respond number 1. Respond number 1. Page
One.
68, Lordship.
68.
Page 68.
Richand Ahmed.
It is
Richand Ahmed.
Moromi Paying, Lordship.
Moromi Pang. Richand Ahmed is there 52 years.
I think, my lord.
Joint Secretary.
176 to 196, my lord. 176 to 1.
You're on Moromi.
Recent one.
Recent one.
But it is wrongly taken from the
Total he running page to apni kone niki?
once.
Running page to 176 or pura asile.
Moromi Pang, yes, we
Moromi
have.
Payang, my lord. Deputy
At
Secretary.
176. Yeah, earlier it was 68. You are correct.
Yes, Lordship. It is page number 2, Lordship.
Uh,
Sorry, paragraphs 2, Lordship. Paragraphs.
Paragraph 2.
Yes, Lordship. Paragraph.
Yes, please.
That this honorable court of High Order dated 29/03/2022 directed us to file an affidavit on specific query made whether the Finance Commission has made any recommendation as regards the arrear salary of those persons of Sincere Medical Board who had retired prior to the adoption of the ROP Rule 2010.
When was the, when is it adopted? ROP?
2010.
Rule is 2010, my lord. It is a 6-pay commission, my lord.
Okay.
Now, here, this honorable court of High Order dated 21/10/2022 has also directed us to bring on record by way of an affidavit that if the municipal board takes a decision to revise the pay and allowances of the employees, including retired employees, in conformity with the Assam revision of pay rules 2010, then what is the procedure to be followed for sanction of such additional amount, and whether it should be a part of the grant in aid to be released in favor of the municipal board under Article 243Y, read which Article 243I of the Constitution of India. This affidavit shall contain the procedure followed in relates to the disbursement of the pay allowances to the employees of the municipal board when the municipal board took the decision to pay its employees the
pay and allowances is confirmatory with the revisions pay rules for the earlier years, Lordship. That is the step. First. Next, Lordship, in paragraph 3, Lordship, that regarding the queries made by this honorable court, your deponent begs to state that under Article 243Y of the Constitution of India, the Finance Commission Institute under Article 243 capital I shall also review the financial position of the municipalities and make recommendation of the government as to the principles which should govern the distribution between the state and municipalities of the net proceeds of the tax, duties, tolls, and fees liable by the state, which may be divided between them under the part and allocation between the municipalities at all level of their respective shares of such process. The determination of the tax, duties, tolls, and fees which may assign to or appropriate by the municipalities. The grant in aid to the municipalities from the
Now, those are okay.
Yes,
This
yes.
forms a part of the grants in aid by
Yes,
the
Lord.
state. It cannot be as a matter of right.
Lordship.
So are you in a position to give the grant in aid, to give the benefit of the pay commission recommendation to the petitioners?
That is not there.
Not possible.
Yes, Lordship.
Mr. Datta, before you had taken the resolution, you must have done some homework, some exercise that resolution cannot be adopted on paper. It has to be actually translated
Exactly.
into work. So before adopting the resolution, you must have done some examination that from these funds will be able to give them the benefit. Now, what was your exercise? How did you adopted the resolution?
The same question I put to the then chairman while he was there.
Hmm.
Now, it appeared to me just a casual resolution they made, because your lordship kindly see, there is a big mismatch between the revenue.
Receivable and the payable.
My lord, and all the time we have found the collection, whatever comes, far in less than the expenditure. Now, in that scenario, my lord, to take a resolution to that effect, which it includes a crores of amount. Now, unless, my lord, there is only way.
How are you managing to give to the present employees?
The present employee after 1/10/2014, there is the government instruction is there. They provided certain fund for 6 months, and after that, that fund was also stopped. Now, whatever the revenue generated, my lord, they are having always shortage. There is a huge amount of deficit, and the employees get salaries even after 6 months, sometimes after 10 months. Well, all through is a chronic things happening. Therefore, my lord, this resolution, they could not reply to that. Therefore, my lord, we could not explain it also in our affidavit. So, therefore, only one way out, my lord, as your lordship understands, whether the ROP can be adopted by the insert board, because it's a, my lord, full-fledged is a autonomous body. Now, they are dependent solely on their own fund, and the own funds are always lacking. Is not even, they cannot pay their salary to the staffs. Now, in that sort of scenario, my lord, your lordship can only, if your lordship want to solve the matter, my lord, your lordship can ask us to write the finance commission and under article, my lord, 243Y.
That Mr. Goswami has already explained.
Yes.
No, he has explained that there is a provision for grants in aid. 243, I read it 243Y.
Yes.
But
lordship judgment, my lord, in similar matter in case of this municipality, your lordship given a direction. In paragraph.
But Mr. Datta, having expressed their stand by way of an affidavit, will a direction for considering again
No,
would come?
that direction not to the finance department.
Then-
Your lordship may ask us to write to the finance commission to get a grant in it to mitigate the situation. That is the only way out so far I feel. Otherwise, own resources are very much lacking. And as your lordship knows that the actual implementation of the ROP is always dependent on the self-sufficiency. In paragraph 29, your lordship explained that, 29 and 30. We are facing similar situation in all the cases. If there is
Condition.
relating to water fee.
Lalaki, Paramjit Singh, case 2. Judgment. Yes, yes.
That was a different case. The services were handed over to the, petitioners were of the boards now handed over to the urban bodies.
Yes, the facts of course, obviously it's different, but then question of law, so for payment of the salaries and all that, dependent on.
No, Mr. Doctor, if we accept your suggestion rather, that we ask you to seek funds, that would have been proper if the stand of the government was fluid. Stand of the government has been made known that in spite of 243 I and Y, they are not in a position to make grants in need. So we cannot.
But then, my lord, they cannot say no because of constitutional provision. My lord, can I take your lordship to that? Article 243, why?
Yes, please. Economy.
43 by Finance Commission.
Then the question might arise on the authority of the board to adopt a resolution which was not per se for you. It was for the state government employees.
My lord, your lordship, can
That question would arise.
Yes.
But services of the petitioners are not provincialized.
No, the
Employees are provincial, not
They are
provincialized.
not provincialized employee. So they cannot ask that we are bound to pay the ROP.
No, even otherwise, ROP, will it be applicable per se to the employees under the board unless you adopt?
My lord, we only by virtue of resolution, they have said, my lord, only that 40 parties there. Otherwise, my lord, we are not bound. Because we do not have our own resources. Because if there is no fund, and my lord, we take a resolution, it's a no resolution at all. And the law never stipulates that we have to accept that whatever the state government is passing. Day-to-day implementation is always dependent on our own source of fund. And funds position, if your lordship, almost all the municipalities position is very.
This finance commission, which is it defined, finance commission?
Yes, that your lordship may kindly see Roman 3. The grants in aid to the municipalities from the consolidated fund of the state. Because invariably, my lord,
Who is the finance commission here? For the state of Assam?
that I'm not sure.
Mr. Goswami? It's the department, not the department, cannot be the department. We don't have a finance commission.
Because in
Hmm? Then who takes care of this kind of situation? The finance department. No, commission is not there. No, we are on the context of 243Y, which contemplates a finance commission to look into the activities, financial position of the municipalities, specifically for municipal. It cannot be a periodic kind of a commission. It has to be a permanent commission. So if at all we are agreeing with with the suggestion of Mr. Dotto, and we ask only for a resolution of the dispute, we ask them to write to the by exercise of powers under 243Y, whom they will approach.
The state of the governor can constitute.
No.
Your
Is
lordship may see-
it
see,
defined, finance commission? It's not defined.
Your lordship may see.
Let us see I, what is I 243 I? I will clarify everything.
Yes, yes.
Yes, my lord, yes. Under.
There is yes.
The governor of a state.
It's a state, not the center. State,
The statement.
they will constitute.
The state has the equal power. The government of a state shall, as soon as may be within 1 year from the commencement of the constitution, and thereafter at the expiration of every 5th year, constitute a finance commission to review the financial position of the panchayat and to make recommendation to the governor as to the principle which should govern, in regard to
No, this has been made applicable for municipalities under 243Y. Therefore, 243Y has to be read with 243I. That finance commission was primarily meant for panchayats. And it has been, the functions have been extended even for municipalities by 243Y. No, here they are all retired. Here they are all retired employees. Whatever they'll get, it is not of a continuous nature. It will be a one-time amount.
the revenue gap that sometimes.
Evolution fund is for revenue gap.
Certain amount of money from the consolidated fund of the state. So as without every expense of the particular.
No, that cannot be. This municipality, they have to generate their own funds. No, see, we are broadly on the aspect that no enforceable right is there, but we are trying to find out a way to resolve the issue. See, the adoption of the resolution does not appear to have been done after a due diligence exercise. There is no exercise. But when we find that the later employees have been given the benefit and they are fighting for a period and they have also already retired. Now their claim to be can be quantified. It cannot be in the infinite. It's quantifiable. And that is exactly where we are trying to say. You are not getting it. We are not trying to put burden upon you. But municipality also has got the provision to seek grants in case of need. Now, how much that would be applicable or enforceable, that's a different matter. But since an resolution was adopted to give them certain benefits, one section of the employees who have retired, and their claim can be quantified now. We can, this is suggestion of Mr. Datta, we can give the liberty to the municipal board to write to the and administrative the department will take a reasoned order. We are not saying that it has to be given, but you have to take a reasoned order. And if possible, try to emulate their condition. That's all. We are not going deep into it. Okay.
The existing employee supplement we are giving on 1/4/2014, which your lordship will get at page 134.
You had said that it was given for 6 months.
Initially, the government grant was for 6 months.
6 months.
Your lordship will find that at page 134 of.
1/10/2014.
Yes. 1/4/2014.
Okay. Both. Please, Mr. Sharma, have this it. Both the petitions being connected are have been analogously heard and are disposed of by this common judgment and order. The petitioners are retired employees of the Silchar Municipal Board. And they had retired in the period from 2010 till March 2013. Full stop. The board had a wider resolution dated 29/8/2011 had resolved to give the benefit of the ROP 2010 to all the staff. Full stop. However, it was also resolved that such benefits be calculated from 1/1/2006. Full stop. However, such benefit was not given to the petitioners, and accordingly, petitioners, and in the meantime, they had retired. Full stop. Accordingly, they had instituted the first writ petition, WPC 4675 of 2016, in which there was an order dated 8/8/2016 to consider and dispose of the representation. Full stop. The stand of the board, as would reflect from the communication dated 18/5/2016, is that such benefit can be given as and when funds are made available to the board. Full stop. The petitioners had instituted a second writ petition 6030 of 2016, which was also disposed of via an order dated 3/10/2016, directing for consideration of the representation. Full stop. The board, via a communication dated 31/10/2016, had made their position clear that if and when the government makes the fund available, the payment can be made. Full stop. As the benefits were yet to be given, the present writ petitions have been filed, wherein the contesting respondents have also filed their affidavits in opposition. Para. I have heard Sri J. Sharma, learned counsel for the petitioners. I have also heard Sri J. K. Goswami, learned additional senior government advocate, Assam, and Sri S. Datta, learned senior counsel, assisted by Sri Siddhant Datta for the Silchar Municipal Board. Para.
Now corporation. Now it is corporation.
Silchar Municipal Corporation. Full stop. It may be mentioned that as and when the writ petition was instituted, the nomenclature was Silchar Municipal Board, which was subsequently made a corporation. Para. Sri Sharma, the learned counsel for the petitioner, by drawing the attention of this court to the resolution dated 29/8/2011, has submitted that once such a resolution was taken, it was incumbent upon the board to give the benefit to the petitioners. Full stop. He has highlighted that so far as the subsequent employees are concerned, such benefit has been given, and only the petitioners who had retired before March 2013 have been left out.
Yeah.
Full stop. He has submitted that though the board of the corporation is required to generate their own funds, there is a provision for seeking grants from the state. Full stop. He has submitted that, in fact, the benefit to the subsequent employees have been made on the basis of grants provided by the state. Full stop. He accordingly submits that there cannot be any discriminatory treatment so far as the petitioners are concerned vis-a-vis the employees who were serving at the time of retirement of the petitioners. Para? 3. Goswami, the learned state council, has submitted that the salaries and other expenditures of the board of the corporation have to be generated by its own, as there are various mechanisms of revenue generation. Full stop. He has, however, submitted that at times the grants is given by the state, which has to be properly justified. Mr. Are you also appearing separately? No. Or then come to Lihiba Agote, our board president finance department. Para. 3. The London State Council has also drawn the attention of this court to the affidavit in opposition filed by the respondent number 1 on 2/2/2023, wherein the provisions of the Constitution, namely Articles 243 within bracket capital Y and 243 capital I, have been dealt with. He has submitted that the board of the corporation is an autonomous body and has to generate its funds, and on meeting the prerequisites, the state may provide for grants in aid. Full stop. There. 3. Board Pujari, the learned Standing Council Finance Department, while endorsing the submissions of the London State Council, has contended that the resolution itself appear to have been taken without any proper application of mind. Full stop. He has clarified that the benefits of ROP would not be per se applicable to the employees of the board of the corporation, and if at all the same is adopted, the same has to be done by doing an extensive exercise, more particularly with regard to the fund position. Para. 3. Datta, the Learned Senior Counsel for the corporation, has candidly submitted that it is not in dispute that resolution number 8 was indeed adopted on 29/8/2011. Full stop. He has, however, submitted that it is not clear from the records as to under what circumstance such resolution was adopted. Full stop. He has submitted that the fund position of the corporation is erratic, and even the monthly salaries are not being able to be released on time. Full stop. Para. So far as the submissions made that subsequent employees, that certain employees who were serving have been given the benefit, the Learned Senior Council has submitted that grants in aid was provided by the government on 1/10/2014, that too for a period of 6 months, whereafter such grants in aid was not provided. Full stop. He has submitted that he has reiterated that though the benefit has been given to certain employees, those are also done in a most irregular manner, as the fund position of the corporation is unstable and poor. Full stop. Para. From the materials available on record, it is not in dispute that resolution number 8 was adopted by the Board of the Corporation on 29/8/2011. Full stop. Para. For ready reference, the said resolution is extracted here in below, page 42. Page 42, Annex 5. The resolution would reveal that the employees of the board were enjoying the scales and allowance of the state government employees since 1974. And since the ROP was and accordingly the benefits of the ROP 2010 was thought to be granted. Full stop. While this court is not raising any issue with regard to the bona fide of the said resolution adopting the ROP of 2010, it is not clear as to how and from where the funds would be generated to be paid to the employees in terms of the said resolution. Full stop. Para. At this stage, it would be relevant to mention the constitutional provision connected to the issue. Full stop. Article 243Y is with regard to a finance commission which is constituted under Article 243I, which would also review the financial position of the municipalities and make suitable recommendations. Full stop. Such recommendations would also be on the aspect of grants in aid, of providing grants in aid to the municipalities from the consolidated fund of the state. Full stop. As noted above, the Finance Commission is constituted under Article 243I. Full stop. For ready reference, both the articles are extracted here in below. Full stop. Para. As would be clear from the aforesaid provisions, the Commission would have the power to recommend to the state for providing grants in aid to the municipalities. Full stop. Municipalities from the consolidated fund of the state. Full stop. Though the act of adopting the ROP 2010 by the resolution dated 29/8/2011 cannot be said to have vested an indefeasible right to the petitioners, taking into consideration that certain employees have been indeed given the benefit of such adoption, interest of justice would require that the Board of the Corporation would write to the appropriate authority for providing grants in aid to the corporation so as to take care of the situation which has arisen out of the resolution dated 29/8/2011. Full stop. Para. The Silchar Municipal Corporation is accordingly directed to place the entire matter before the appropriate authority along with the relevant information, including the requirement of funds which would be considered by the appropriate authority in accordance with law and by passing a speaking order. Full stop. The writ petition according stands disposed of. Both the writ petitions according stands disposed of.
May please, your lordship.
India Council is on legs in another court.
My lord, we have a discussion with TJ Mohanta, my lord. Actually, I'll make a prayer for adjournment, my lord. The matter is something.
17 matter, why should we adjourn?
My lord, actually, this case.
I will accommodate Mr. Mohanta, you can complete your part. Or you want to do it 2 o'clock, we'll do, allow you to do it 2 o'clock. 17 matter, we are not, both the matter, councils are there, unless there is some grave urgency or emergency,
My
you are
lord,
not there.
in respond number 7, filed a petition challenging the appointment of the respond number 6. And I was not made a party there. I have.
What is the issue?
Issue is a lecturer of oral pathology, oral microbiology of Regional Dental College. And while I have.
And you are for the private respondent,
No,
Madam
APSC.
Sharma?
APSC.
APSC, who is for the private respondent?
My lord, that is the problem. My lord, private respondent number 7, who initially filed the case challenging the appointment of respondent number 6, she withdrawn. And
that case has been withdrawn.
And so far, thereafter, APSC has filed an affidavit in opposition in my case. Belatedly, I filed a reply in the next occasion on 5/6. And as per notification, I have to serve copies of all the advocates. I could not serve the copies on the respondent number 6 because I contacted them. They refused that we do not know about this case. Whether respondent number 6
No,
is.
if they are not interested, we will not hear them. If they have been, if the names of the council are appearing, this is item number 21. Who's the council?
PD Kumar was appearing initially. Respondent number 6.
Just a minute, please.
For respondent number 7, UK Nair, Honorable Justice UK Nair appeared, and that case is withdrawn.
Mr. Mohantov, MP Sharma. R7 MP Sharma was there. MP Sharma. H. Agarwal. H. Agarwal means BD Kumar. Health Department. Where is Health Department? You are for the Health Department. Mr. Goswami, councils we have.
And one.
We have been able to point out get the names of the councils. One MP Sharma is appearing for one of the respondents.
She last occasion she called many of the advocates. Everybody said that we will have to check it. Huh? My God.
No, so far as BD Core is concerned, you have said, but there is another private respondent who was earlier represented by Justice Nair and now presently represented by PN Sharma. MP Sharma.
I think.
Can you have Mr. MP Sharma?
Awesome.
We don't, first we don't want to adjourn the matter, and if at all we adjourn, then we bring it to a certainty that the council should be knowing that this matter is to come up on a particular day. Otherwise, it will be again be adjourned. Can you get Mr. Sharma?
My lord, there is another one problem, my lord. The file for promotion has been moved, my lord. In a short time, if promotion is given effect to my lord, if I'll get the promotion, my lord, or others will get the promotion.
You are in which post now?
I am working as a lecturer of oral pathology.
Lecturer post.
Lecturer.
What is the next promotion?
Next promotion is
Assistant professor.
I am posted in Dibrugarh. Everybody is posted, my lord. Everybody is posted. Everybody is working, my lord.
So what is your cause of action?
My lord, my cause of action is this. I have obtained a certified copy of the repetition filed by the respondent number 7, challenging the selection of respondent number 6. And I came to know the marks given to them.
Okay.
I have secured the highest marks in academics. I have the additional qualifications. I have the additional qualifications, and at the same time, I have the experience. In spite of that, I have been given the less marks.
Your cause of action is giving less marks in the selection.
Selection.
And the marks you could know from the proceedings of the writ proceedings instituted by the respondent number 7.
My lord. Then I found that I'm
Yes, Health Department, madam, what do you say? Who? Who? He has the records. Do you have the records? When is he coming?
my
We'll do one thing, we'll have your matter after some time. Call Mr. MP Sharma and call Mr. Upadhyay, Upamanyu. Or you can have it at 2 o'clock also, no problem, whenever you are there.
my,
Let them come, one more matter we'll have, then we'll have your matter.
my lord, only one problem. I'll be at 2, my lord, no problem, my lord. Due to our understanding, my lord, I could not go through the petition. I may be somehow.
You don't need time to go through a petition, Mr. Goswami. You are a seasoned counsel.
I may be excused if I fail, my lord. That's
You
my
never fail. You'll not require more than 5 minutes.
My,
But we'll accommodate you. But we want to, even if we adjourn the matter, we want to adjourn it in presence of the council so that on the next date, because names have not been reflected. MP Sharma, neither MP Sharma nor the other one, BD Core.
my lord.
After a while.
My lord. At 2, my lord.
Whenever you say. If they come before 2 also, you can have it. Or at 2 o'clock, whenever you say.
2 o'clock, and
at 2 o'clock?
We'll also try to find out that.
Yes, yes, please
at
do.
2 o'clock.
Okay.
22.
My pleasure, Lordship. Here the petitioner is before your Lordships claiming his 2 additional increments along with his pay band, which was given to the similarly situated person as a promotional post. And the second prayer was regarding his designation in the post.
Yes, ma'am. Who you're for the respondent?
On behalf of senior counsel.
I have been told that I can.
He'll be here shortly.
They are the contesting respondent.
Yes.
You are working with them.
Yes, under the Toklai Tea Research Association.
You are the Toklai.
Yes. So my prayer is twofold, Lordship. One is regarding my additional increment. Second one is my designation. And
just a minute,
Lordship.
One is increment.
Yes, Lordship. 2 additional increments along with the pay band. And second one, I am not praying, Lordship, as because I have left that institution and I have joined as a registrar in the NIT at Meghalaya. But regarding that additional increment, it will help me in getting the salaries there, Lordship. So the second part, Lordship, regarding my designation, I am not praying. Now, I draw your Lordship's attention to page 18, Annexure A. That is the initial my appointment letter. Page 18, Annexure A. So, this is of 6th of August 2007. I was appointed as administrative officer at Toklai Experimental Station, Lordship. Thereafter, you can skip this one, Lordship. Then page 22, this is the confirmation after 1 year of
Page
22, Lordship.
Is what? Confirmation.
Lordship. Confirmation is page 24, Lord.
22 is joining. Joining is okay.
Joining, that is joining letter. 24 is the after probation period, completion of successful probation period of 1 year, Lordship. Page 24. That is 2nd of September 26th of September 2008. I am pleased to inform you that on completion of your probation period of 2nd of September, the management has decided to confirm you in your Lordship. Then
Okay.
page 26, Lordship, that is my promotion letter. 23rd of January. Page 26. I am pleased to inform you that based on the assessment interview held on 3rd of January 2013 and subsequent recommendation of the expert committee is decided to promote you to the next higher pay band of rupees 37,400 to 67,000 PB4 plus grade pay of 8,700 in the grade and grade AD4 with effect from 1 to 2013. There is no dispute up to this, Lordship. Thereafter, Lordship, this is page 29. That is my resignation letter. We can skip this one as because I am not paying for this. Then Lordship may kindly come to page 31, annexure F. I have written a letter, Lordship, page 31, annexure F. I have written a letter to the director of Tea Research Association, Toklai Tea Research Association, dated 26th of June 2013. That may I read, Lordship? I would like to inform you that on scrutiny of my band pay fixation, it was noticed that my band pay was wrongly fixed at rupees 37,400 without allowing 2 additional increments as per rules conforming to CSIR notification number so and so, dated so and so. The correct pay band should be 40,220 with effect from 1 to 2013. That is the date from my promotion. And the main dispute is we are on that Tea Research Association is following the CSIR rules. CSIR means Lordships Council for Scientific and Industrial Research. And according to them, they are following CCS, Central Civil Services rule. Because of that, I have been deprived from these 2 increments. Now, your Lordships may kindly come to next page, Lordship, annexure G, page 32. Annexure G, page 32. The column, Lordship, here, Lordship, my pay band is fixed at, this is grade Roman 4 within bracket 4. That revised scale of pay rupees 37,400 to 67,000 per band and grade pay of 8,700.
You are 4-4.
4-4. Now, Lordship, this serial number 2, all the scientists in pay band 3 with grade pay of so and pay band 4 with grade pay of 8,700 to 8,900 shall be given 2 additional increments after their normal pay fixation. My submission is that we have been treated at par, Lordship. The scientists as well as we, the administrative officers, are treated as at par, Lordship. Accordingly, we should also be given these 2 additional increments. Then, Lordship, annexure H, this is also a representation from my side to the director of Tea Research. We can skip this one. Then, Lordship, this annexure G, annexure H, page 34, this is a letter from me to the director again, Lordship, praying for that corrected pay band should be 40,220. Against this letter, Lordship, the
34 is written by you.
Yes, Lordship. To the director.
Representation.
Lordship. Thereafter, annexure I, page 35. This is the clarification.
No, we have understood your case representation, unless you have
Yes,
something
yes.
else.
I will skip the representation. I will skip the representation.
You are basing your claim on the communication made by the CSIR in November 2008, whereby the scientists were to be given two increments.
Lordship.
You say that your position as administrative officer is at par with the scientist,
Lordship.
and therefore you should be given those two.
Lordship.
That is your case basically.
This is an important document, Lordship. May I please this one?
Yes,
This annexure. I will skip that representation. This annexure I, Lordship. This is a clarification by page 35. Annexure I. This is the clarification made by the financial controller, T Research Association to the director against my that letter annexure H.
Who has written this?
This is written by the financial controller, TRA, T Research Association, to the director. Yes, Lordship. May I read, Lordship? This is an important document.
Yes.
The rule referred by the administrative controller states that scientists in PB3 with grade pay of so and PB4 with grade pay of 8,700 to 8,900 shall be given two additional increment after their normal pay fixation. The two additional increments shall be computed on pay plus grade pay at the time of entry in the grade. It will remain constant during the entire period of residency in the grade and will be recomputed on the promotion to the next grade. This CSIR circular is only intended for grade 4 scientists. It is not applicable for administrative and other employees. The next paragraph. However, TRA has followed CCS, RP rules FR 21(1)A so and so uniformly to all of its employees for pay fixation, which states one increment equal to 3% of pay in the existing pay band shall existing grade pay, which will be rounded off to the next multiple of ₹10, and this will be added to the existing pay in the pay band. So according to this financial controller TRA, the TRA is following CCS rules, not CSIR rules. That is why I am placing this document. Then, Lordship, again my representations we can skip. Thereafter, Lordship, page 39, there was a dispute between the management of TRA and the union. As because after that, Lordship, the service rule was formulated, and there they have specifically mentioned that the CSIR rules will be applicable. Page 39, this is the memorandum of settlement. Annexure K. This is regarding an industrial dispute, the management of Tokla experimental station and the workmen represented by their union. We can skip this page, Lordship. Then, Lordship, page 41, this is the agreement. This is regarding reference number 11 of 1965. An agreement.
What is this agreement?
Agreement is at page 41.
What is this agreement?
Agreement is the CSIR rule will be adhered to and adopted.
Where is it?
At page 41, Lordship, third line, first paragraph, Lordship.
What is the date of this agreement?
This date of this agreement, Lordship, page 58. Lordship, let me. Day of August 1965 at page 56, Lordship. It is agreed that the so and so clauses are acceptable to the aforesaid parties, and this agreement is made on this 31st day of August 1965. Thereafter, Lordship, another reference at page 58. It is of 1997. In typed copy, Lordship, the reference case number was wrongly typed as 9. It should have been 5. This is dated 6/4/1998. This is also amicably settled. your lordship may come to the directly to the settlement. Starts,
What is this award about?
yes, lordship, this is also that it has also been agreed that any difference of opinion at page 62, terms of settlement 3B. Terms of settlement 3B. It has page 62. It has also been agreed that any difference of opinion of the implementation of the service will be discussed mutually with the union and disputes on pay scales and allowances settled in terms of Government of India rules, while the service conditions as per Government of India FR and SR CSIR. And this was signed between the parties at page 65, 26/12, 1997. Lordship, then CSIR rule is applicable. Then your lordship may kindly come to the directly page 76. This is a letter written from their end, lordship, by the director to the present petitioner. This is an mail, lordship, page 76, annexure 10. May I read, lordship? Mr. Chakraborty, I have not been briefed earlier about this. In principle, no retrospective action are being taken in TRA due to the difficulty of getting retrospective approval from T-Board and Commerce Ministry. However, for prospective correction, I will discuss the issue immediately with the concerned persons, have them revert to you.
Who is this writer?
He is the director, lordship, this Prabhat Besbarua. He has written this to the Joydeep. Joydeep is the director, lordship. So this is the last communication from them, lordship. Thereafter, on the basis of the 97 agreement, lordship, the mutual agreement, that annexure just now I have placed before your lordship. On the basis of that agreement, the service rule was adopted by the Department Research Association. Because it was not annexed in the repetition, I am placing the service rule before lordship directly. Only that 2 flag marks will do, lordship. Only that 2 flag marks. The first one, lordship, this is the service rule of the TRA. The first one, the marked portion 1.4. These rules shall come into force with effect from 1st of January 1998 in supersession of all existing bipartite and tripartite agreements and may be amended. And agreement and may be amended by the Council of Management of the Association from time to time with reference to the rules and conditions of service as applicable to the Government of India, CSIR. Then lordships may kindly come to the next flag mark. Next flag mark, lordship. That is the designation down below grade 4. Scientists grade 4, grade Roman 4 within bracket 4.
Yes.
The existing grade pay lordship 4,500 to 5,700 and 14,300 to 18,300 at that point of time. Then next page, lordship. This next page, lordship. This
No,
this
this we have
group,
not understood this.
lordship.
Scientist 4 is existing pays 4500 to 5700.
India 1998, that was the
Okay.
because that I am just specing that the pay scale is similar to the scientist with the administrative officer. Next page, lordship, that group AD4 administrative officer / accounts officer has your lordship got it.
Just a minute, please.
Next page, lordship. The in the middle portion, group AD4 Roman 4, administrative officer, accounts officer. I have marked it. Lordship. AD4 Roman 4 within bracket 4, 4,500, 5,700 and 14,000. The same pay scale, Lordship. We have been given the same pay scale. Then I am coming to the affidavit in opposition filed by the respondent number 5, Lordship. Most probably the running page is not there, Lordship. I am.
Is there? Is there.
Rely-
By R5.
By R5, R5.
Shantanu Bhuya.
Yes, Lordship, yes. Then paragraph number 8.
Page 85.
Internal page 5. Lordship.
85 AIO by 2018.
May I read that?
Internal page?
Internal page 5, paragraph 8.
At page 89.
Yes, sir.
Yes.
That with regard to the statements made in paragraph 8 and 9 of the writ petition, the answering deponent begs to state that the findings of the financial controller TRA is not illegal and perverse as stated by the writ petitioner. The financial controller TRA, vide his letter dated so and so, had correctly pointed out that the CSIR circular was only meant for group 4 scientists and not for administrative and other employees. It is also true that TRA has been following CCS rules 2008, apply uniformly to all its employees for pay fixation. The very interpretation of the writ petitioner that TRA has been following CSIR and not CCS rules and regulations for fixation of pay is not at all true. The answering deponent further states that TRA service rules was introduced with effect from 1/1/1998 as an understanding between the employees union and the management. The rules and conditions of the service which has been laid down in the service rules are legally applicable to the Government of India, CSIR. However, it is pertinent to mention herein that nowhere in the Memorandum of Association or in the rules of the association or in the TRA service rules, it has been mentioned that TRA has to follow CSIR rules in its totality. How they have come to this conclusion, I do not know, Lordship. The Ministry of Commerce, which contributes certain percentage of salary and other specified costs through tea boards of India, specifically right so and so, so and so. So, Lordship, apparently in the service rule, it is mentioned that CSIR will be applicable. My salary is equal to the scientists. In all along, Lordship, we are getting the same benefits, equal benefits. When this time it has come down, they are just make a somersault and say that only CCS rules is applicable, not CSIR. Then what is the service rules, Lordship? And another document is also with me, Lordship. I can place it if your Lordship desires, but most probably this is a report of Committee for Revival of Toklai Tea Research Institution, Jorhat. Here also I can place the page numbers where it is specifically mentioned everywhere that CSIR rules is applicable.
Okay, we'll come to that aspect if required.
Lordship. So mainly this is my case, Lordship. And their main contention is that, Lordship, in TRA, CSIR is not applicable, only CCS is applicable. But everywhere it is mentioned that it is, if the CSIR rule is applicable, in that case I am entitled for that 2 additional increments. এখন কে নালাগে বুলি কৈছে দেখোন if your Lordship desires, I can place this one.
That will find.
Lordship.
So what you if you sum up your submission, you say that administrative officer and scientists are at par, same pay scale.
Lordship.
And in the service rules, there is a direct mention of CSIR.
Lordship.
There are memorandum of agreement.
Lordship.
Wherein they have said that they will be for giving the benefit of under CSIR. Under those circumstances, not giving the benefit of 2 additional increments to you will be arbitrary.
And their contention is not that in spite of CSIR is applicable, I am not entitled to. As CCS is applicable, because of that I am not entitled to. They are not nowhere they have stated that only the scientists are this applicable to the scientists. That as because CCS rule is applicable, because of that I am not entitled to. Had it been CSIR, I am entitled to, Lordship. If something to add, Lordship, I can make the submission as a reply.
Yes, Mr. Sayala.
My lord, you're also going to see the letter page 32 again.
32. Yes.
See, we only apply to this is issued by Council of Scientific and Industrial Research, New Delhi. Address to Director, Head of National Lab Institutions. So, National Lab Institution. Then subject, implementation of 6 Central Pay Commission recommendation in CSIR in respect of Group 4 scientists, not for others. Group 4 scientists. Now I know.
Yes.
In continuation of this office letter number so and so, communicating the decision of the competent authority for the implementation of the 6 CPC recommendation in CSI in respect of the staff and other than Group 4 scientists. In respect of the staff other than Group 4 scientists.
Yes.
And to state that based on the recommendation of the committee, DG CSI in consultation with the FA CSI has been pleased to implement the 6 CPC recommendation in case of Group 4 scientists to the extent mentioned below. The other recommendation of the committee will be taken up with the Ministry of Finance, Department of Expenditure separately for approval. Then now, there are 2. All the scientists in the pay scale band 3, grade pay of so and so, and band 4 with grade pay of so and so, shall be given 2 additional increment after their normal pay fixation. So only scientists, not the officers. Each increment shall be calculated at 3% of the total basic pay in respective pay and band plus corresponding grade pay for those recruited, promoted with effect from 1/1/2006 or from the date of option exercise for the revised pay scale in respect of the recruited, promoted report 1/1/6. The 2 additional increments in PB 3 and PB 4 shall not be treated as a part of pay for any purpose and shall be computed on the pay plus grade pay at the time of entry in the grade. It will remain constant during the entire period of residency in the grade and will be recomputed on promotion to the extent of grade. Scientist payment for and so and so, grade pay of so and so, you get paid 4,000 per month as per recommendation of the 6. So, my lord, this is especially, my lord, and para 6 may be seen, my lord.
Para 6, not 6, 3.
Oh, sorry, 5.
5.
The fixation of pay and payment of arrears of Group 4 scientists may be regulated as per CCS revised pay rules, notified by GS number so and so, and the instruction contained in Ministry of so and so, number so and so. The 10% of the additional account of the revised pay structure based on CCS may be met out of laboratory reserve fund So madam, they have given because this is issued that from this fund they can be paid. The additional increment has been given to scientists. Because this letter has been issued, my lord, that is very important, my lord. Letter has been issued to the all director heads of national labs and institutes. This is in respect of scientists only, my lord. This is as per the pay commission, my lord. Now, my lord, you have nothing fine. My non-parent read the page, para 8. I'm just reading para 9 also. my lord.
Of which page?
Page 86, 85. Page 85. No, para 10, my lord, page 86. my lord.
Para 10 you'd like to read?
Fine.
Of the affidavit filed by Shantanu Bhuyan.
My lord. Regarding statements by the paragraph 30 or expression being entirely misconceived.
That is page 90. 90.
90.
Paragraph 10 you're reading.
My lord.
Yes.
That with regard to statements made in paragraph 30 of the expression being incorrect and misconceived, the same are being denied and answering upon. Without which is answering upon back to state that controller discretional is not assigning him the direction of the senior controller of administration is totally baseless as because the TRS service rule that the ignition of the administrative officer is highest post in the cadre. The answering opponent further states that the main objective behind the JCS committee report was to provide an insight into the promotional procedure adopted at TRL and to suggest the method to detect the grievances of the employee related to assessment and promotion.
That prayer, Lordship, I have already.
Coming. However, as regards the definitions of the employees of TRL management has changed the definition of the employees in the light of the committee report. In CISR, the administrative controller is looking after the administration of bigger CSI laboratories like NPL, and only in their cases, senior controller administration is there only in big CSI laboratory like NPL. The answering the opponent states that this is important matter. Answering the opponent.
Yes.
Answering the opponent states that just to keep at par the position of the financial controller of the TRA, the position of the administrative officer in the grade pay of 8,700 was designated as administrative controller. Further, the decision indicated that the official title, which the management and computer authority decided by the employee job responsibility qualification, then same cannot be in any manner claimed by name. Then para 13.
Yes.
That with regard to statements made in paragraph 18 of the petition, the answering upon the category denies the allegation of the petitioner to affect that here is never differentiated between scientific and non-scientific. The answering opponent submits that there is a clear differentiation of scientific and non-scientific cadres in TRS service rules and also in CISR number so and so. In TRS and CISR rule, it's really mentioned that about the differentiation of the scientific, technical and administrative support staff. The lead prisoner has stated that pay scale of secretary and financial controller of PRA, to which the answering opponent begs to submit that pay scale of secretary of the association is decided by the Council of Management as secretary works under the direct supervision of the guidance of chairman, vice chairman and Council of Management like other employees. And other than present financial controller is an associate charter accountant who is looking after the financial function of the association. The pay scale of a financial controller is equivalent to position of the district controller, that payment for highest pay, bed and grade. So, my lord, this is the main question that this notification which has been my learned friend is claiming that he should get the benefit, that is especially for the my lord scientists, not for others. Because the fund has to come, my lord, this is a self-malaria. They get little fund from the the keyboard, except that they are not getting any fund. Self-financing knowledge. And that is why the fund has been provided that the laboratory reserve fund from the laboratory reserve fund that we are going everywhere. So, my lord, all the my lord, staff cannot claim this many.
What about incorporation of the CISR in the memorandum of understanding?
That is, they are controlling, my lord, that is why, my lord, not that the FRSR, my lord, that says. If you also see that, my lord, that page 61 of the picture. If B, my lord, page
Page 61, yes.
62, page B, paragraph B, is my translation. It has been agreed that difference of opinion of the influence of service rules will be discussed mutually with the union and disputes of the pay scales announced separately in terms of government of India rules, while the service condition as per government of India, FRSR, bracket scales. FRSR.
CISR.
That, let me say, but that is not a question, but here, as per the Malord, that the notification itself will show in Malord, if you also see that notification is as per the six CPC recommendation.
Page.
That 32. That is as per the Malord, implementation of 6 CPC recommendation. Yes, yes, yes. Because they have their own rules also, my lord. Earlier they were following CCA rules, now they have their own rules. So this cannot be applied to everybody, my lord. The fund, where from the fund will come? If the petitioner is to get, my lord, large number of employees is to get this. There is self-financing institute, my lord. This is a little fund they are getting from the deposit. But this notification is absolutely clear, my lord, that they cannot claim under this one. Letter.
But Mr. Sharma is mainly relying on the memorandum of settlement and the agreement where CIS rules was agreed to be made applicable and adopted. He is also referred to the award.
They go to award that is earlier, my lord. Now they have framed their own rules, my lord. The research their own rule is there. My answer is, my lord.
Now, when the service rules have been pressed into service, the
That 98 service rule is still applicable.
and the pay scale of scientist and pay scale of administrative officer is
Only the same, my lord. Only on the commission, my lord, because that letter has been issued to the labs and institutions, my lord. Because the persons.
This is an institution.
Yes, no institution that only, my lord, because in the laboratory who are working, my lord, as scientists, my lord, they have been given as per the government recommends. That 6 pay commission, 6 CPC recommends. So this on the basis of the letter, he cannot say, my lord, that this is to be applicable to him. Yes, sir, my lord, nothing has to say, my lord, because this is only in the state of this.
Is CSR a party here?
No.
No, Lord.
Any clarification if you require, who will clarify?
That service rule itself specifically states, Lordship. And in addition to that, I am placing one thing, Lordship.
We will come back to you after he completes.
Lordship. It is crystal clear, Lordship. I will show.
Because this is the only thing, my lord, that on the basis of this letter, my lord, he is asking for it. He cannot get it.
Which letter?
Page 32. He is asking only on the basis of letter.
No, this is the basis whereby scientists were allowed to be granted 2 additional increments. Now he says that apart from the fact that the pay scales are similar, that is not his main case. He says that it is the service rule itself talks about CSR. There are memorandum of settlements, there are agreements, and there is an award incorporating the terms of settlement where B has been pressed. That is of 1997.
But later on, my lord, they have framed their own rules. Because they are following us.
So even in the rules, which has been placed on before this court,
Yes. Yes, this is the
rules
This is
and in rules, but rules is only for the purpose of similarity in scale, nothing else,
no, nothing more than that.
only scale. To
But
show
thi-
that
this is
scientist
not
is,
my lord.
the pay band which the scientist is receiving,
That is
you are
not
also
my lord.
receiving.
I am placing this thing only all those paragraphs because that was the dispute. That we should, as because we have been treated at par in getting the salaries. So this additional, this increments, it should also be provided to us by following CSIR.
But this communication of November 2008 confines it to scientists. How are you trying to get it extended to an
That is
industry?
why I am placing Lordship with my learned senior friend.
Okay, we'll come back at 2 o'clock.
Lordship.
You have completed, Mr. Sawala, more or less?
My lord?
You have more or less completed?
Yes.
Okay. Page
Page number 10.
10.
10. I have marked it, Lordship, page number 10 down below. Registration and legal status. The TRA, similar to the Council of Scientific and Industrial Research and the Indian Council of Agricultural Research, was registered under the Societies Registration Act. The TRT was funded by the CSIR from 1st of January 1964 to 31st of 1990. Since April 1990, the Ministry of Commerce and Industry, Government of India has been providing grant-in aid, which was in as high as 80% for so and so. Next, Lordship, the TRA is declared as a scientific research association under section 35(1)(2) of the Income Tax Act for exemption of income tax. Next, Lordship, in the middle portion, as per audit report of 2002 and the audit report dated 24th of May 2006, confirming compliance from TRA, the government rule CSIR will have to be followed in the ongoing organization for service matters and financial matters of employees. While sanctioning 80% grant in aid, the government directed the TRA to adhere to government rules and regulations. Then, Lordship, page number 35. Here, Lordship, in the middle portion, TRA has taken over the management of PROCLI on so and adopted the CSR pay scale and service rules, excluding the pensionary benefits as per agreement with its employees in 1964, and recommendations of all pay commissions have been implemented by TRA since then. Then, page number 63. This is a page number 63. This is a letter written to the Secretary Tea Research Association by the financial advisor and chief accounts officer. Second paragraph. I have done my own inquiries with CSIR and it was found that under the CSIR system, the function of secretary is done by the administrative officer of the concerned laboratory, and pay scale is so and so is to start with, followed by so and finally so and so. When the incumbent is very senior, in exceptional cases, CSIR allows rupees 14,000 at a time for so and so. Then next page, Lordship, page 64. Last paragraph. Since the TRA is following CISR pay scale and we are pressing to the government for revisor of the funding formula to TRA, considering your laboratory as one of the CISR labs, the scale of secretary as offered by you needs to be rationalized as per with CISR. Then page number 92. Only 2 pages left, Lordship. Page number 92. In the middle portion, Lordship, I have marked it there. Page 92. The service rules of the association are applicable to all the branches of the association. All the branches of the association. And Kolkata office very much following the service rules of the in the letter and spirit. Then Lordship, page 94, last one, Lordship. Page 94 down below. Second, last paragraph. In the above context, it may be noted that as per the agreement dated 1st of January 1964, the TDSA Association was formed on the basis of an agreement with the Council of Scientific and Industrial Research, Government of India, that 50% of totalized agreed annual recurring and non-recurring costs would be shared equally between the CSIR and the T-Board, and balance being funded by subscription from members. As per the Industrial Tribunal order, TRA has been following the CSIR scale of pay since 1964 and have implemented all recommendations and subsequent pay commission recommendations. The CSIR and later T-Board have shared the relaxed expenditure of TRA as per the CSIR rules scales. This is my humble submission to the submissions made from the side of the management also.
Okay.
So I have
Hello, 2 minutes, because we have that regarding this paragraph, my lord, in here relied on, my lord, we have replied to paragraph 13. The 2 officers, my lord, they were not given the benefit of 2 increments, but their salary is fixed by the chairman, because they are directly working under that. As for was 6 points. My lord, they are not given, but that is only for the scientific officers. Scientific employees. And that is specific fund, my lord, left fund, from left fund. The fund is to be provided, my lord. One officer, it means if the petitioner is to get the whole employee of the association, my lord. All the employees. A huge fund will be required. They, my lord, financial matter. And now they have framed their own rules also since 1998.
Okay, we'll talk about it. We'll consider this. We'll go through the for each.
Lordship is keeping it CAV.
Yes, we're reserving it for.
Much better.
And who are the respondents? 1, 4, and 6. B. Rabha. P. Rabha on behalf of Vegayan for CGC. Then GN Sahavala, then senior counsel by your name? K. Bhattacharya. So hearing is concluded.
Much better.
Mr. Goswami. Excellent.
The government advocate has collected some instruction, madam.
Yes, we wanted to have your presence.
Yes.
Both Mr. Sharma, then Mr. Upamani, for you, there was a request. But one more, Mr. Who was there? No, that is okay. But Kaur was there.
Yes, madam.
Vidi Kaur. For that response, you are for 6. 7. For 6, Mr. Kaur was there. Where is Mr. Kaur or any of his colleagues? Because why we have called for you that your names are not being reflected. Means Mr. Sharma's name or Mr. Kaur. This is item number what? Item number?
21.
Huh?
21.
21. In fact, none of the private respondents' name have been reflected in the cause list. Mr. Mahanta, for you appear for whom? APSC. So we wanted to hear this matter. It's a very old matter, 17 matter.
He is, his promotion is considered by government.
No, Mr. Goswami said that there is some movement
Yeah, movement.
towards further promotion from lecturer to the post of assistant professor.
Reader.
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 This is equivalent to associate professor.
Or equivalent to associate professor.
Yes, sir.
There is no concept of assistant professor now.
No. So far as I have been informed telephonically, that
Okay.
TPC will be held very shortly, but the exact date is not there. So.
And now here, what Mr. Goswami has contended, not contended, just was fallen from him. We have understood that there was a selection where he discovered from some other writ proceedings that he had secured the highest marks, in spite of which he was not, his client was not appointed and somebody else was appointed. So on coming to know,
highest marks not in the selection process, in academics, I am in highest.
It's self-assessment. It's self-assessment. It is not by the.
no, but he has got the, not self-assessment, he has got the information from the pleadings exchange in the other case. That is what is. Huh? No, doesn't matter. Whether that averment is correct or not, that's a different matter. That may not be correct. That may not be correct. But he said that from that I have come to know that I have secured more marks in academics. So, and I'm left out. What do you say as an APSC? As the selecting authority.
Wait, even then, my lord, your lordship kindly see, in between them, another person is there, but one number 6 is there. He's getting a higher mark.
In interview, his total aggregate marks is less than me in throughout calculation, average calculation. From matriculation.
Now, what are the segments of a selection? What are the different segments? How are the marks allotted? What are the heads of allotting marks?
Since yesterday, my lord, he told me that you're taking time, I haven't done.
17 matter, we don't want to adjourn matters to 17.
My lord, only one thing, my lord, my apprehension is I am also talking to him also. I may win or I may lose, my lord. Since my name is under consideration promotion, my lord, my lord, my case may be infectious also after some time. If we get it sometime or till vacation.
Stay order in this case, my lord. If by this time if post is filled up, then third party, my lord, I will be.
There is a stay order.
There is no stay order.
Now you are holding the post of lecturer now.
Lecturer.
Now they have been appointed as reader.
They have not been appointed as reader.
Then what has happened to the selection?
APSC selection, initial selection. I am not appointed under this selection, my lord. By way of some other selection, I am working, my lord. I want to get this post. I will get the seniority if I will get this post, my lord.
Okay, you have been subsequently appointed in some other selection. And in the initial selection, you contended you should have been treated as a better candidate in the 6 and 7.
Yes, this is my case, man.
And if we agree with you, then you will get your seniority.
Yes, man.
Above 6 and 7. That is your case.
No, if response number 6 has to be set, selection has to be set aside, my lord.
No,
Otherwise,
even if that's setting aside, he's been working for how long? After so many long period, setting aside may not be the correct.
Although there is no stay order.
Setting aside may not be the correct mode. Even if we hold something in your favor, we can say that you should be treated as senior to 6 or 7.
the 7 is already withdrawn. No interest in this post.
Or 7 is withdrawn.
And I am told that this is not correct, clear information. 6 has also no interest. Somebody has told me like that. And if at this juncture I contest with APSC, my lord, I may lose. In that case, I will not get anything, my lord. But if my promotion is considered in the meantime.
No, your winning or losing will not make any difference to your fresh selection. Yes. Fresh appointment, that will make it clear.
Yes.
But what are you seriously contesting this case in view of the fact that neither 6 or 7 are interested in your case? Even if you win today,
yes, my lord.
Are you gaining anything?
Yes, my lord. If I'll get that post, I'll get the seniority, my lord, over response number 6.
Before that, my lord, you have to ascertain whether that post is filled up or not. It is by the government, my lord.
Mr. Upamanyu, post has been filled up. 17 matter, if you do not have instructions, how is it fair to the court? If you don't have instruction, you'll proceed on presumption, withdraw inference. We cannot hold a matter of 17. 10 years writ petition is pending, doesn't look good. And that to selection matters.
No, my lord, we have filed our affidavit in long back
Hmm.
in 2025, 9/9/25. Probably in just 1 day ago, he has filed reply.
On 5/6, 5/6, we have filed a reply, 5/6.
We can do one thing, Mr. Mohammed. We can have this on Monday or Tuesday. We'll finish this off.
My lord. Yes, my lord.
Monday. Monday, there will not be much matters. Motions will be there. We'll have this. We'll give preference to the 17 matter.
My lord.
No. Third, 3. SS Goswami, learned counsel for the petitioner. Also heard 3. T.J. Mahanta, learned senior counsel for the APSC, 3. D. Upamanyu, learned standing counsel health department. 3. A. Chakraborty, learned counsel for the that's number 7. T.J. Mahanta assisted by Miss P.P. Das. P.P. Das. Okay. And central government is a part. Mr. Sarma Barua, why are you here? Are you in this matter? Okay. No. Then we are recording the on a joint request, consideration of this matter is deferred to Monday. List for admission hearing on Monday.
Yep. Item 18 timing.
Item number? Yes, what is this?
Only one thing I would just like to place. The record is there with us. There was one prosecution witness in this, and this is the departmental proceeding is under challenge. One prosecution witness, his evidence we have not been able to find. Maybe it may be a difficulty. Only to that extent, I just wanted to.
Yes, what is it?
Lordship, herein, the petitioner, Lordship, he was serving at the relevant point of time as chief manager, finance and accounts at Gabon, Lordship, Africa, under the Oil India Limited.
Where?
At Gabon, Lordship, South Africa.
Gabon?
Gabon is the name of the place, Lordship.
Not Gaborone.
Lordship, Gabon, G-A-B-O-N, Lordship.
Gabon, okay. You were working as what?
Lordship, chief manager, finance and accounts, Lordship.
Of which Oil India?
Oil India, Lordship.
Chief manager, finance and accounts. Gabon, Africa.
Lordship.
Yes.
Lordship, on 25/7/2012, Lordship, there is an annexure 1. Lordship, an explanation notice was issued to me.
While you were serving
While
there?
I was serving there, Lordship.
Page?
Page 34, Lordship. (25/7/2012), Lordship.
Yes.
May I read, Lordship? It has been observed on physical.
You have been penalized.
Penalized.
Imposed penalty. What is the penalty?
Reduction to a lower stage in the time scale of.
That is this subject matter of challenge.
Lordship, yes.
What are your main grounds?
Lordship, the main ground, Lordship, on 3 counts, Lordship. Firstly, Lordship, this letter was issued in 2012, wherein an allegation was there that impressed cash balance did not match.
No, those are on the merits. On procedural part, what are you? Because our adjudication process would be confined mainly to the procedural part. Merits we may not enter.
Lordship.
DP.
Lordship, that was the allegation. Lordship, subsequently in 2012 itself, it was stated that a warning was issued to me, and that warning was entered in my service records in 2012, Lordship. Thereafter, Lordship, in 2013, the memorandum was issued. Lordship, my first round of challenge is that the warning having been issued in 2012 and the same was entered in my service records, which was used as a ground to deny me promotion in 2014. Lordship, that warning had all the attributes of a censure. Now, Lordship, that.
And the proceeding for all practical purposes had come to an end,
Lordship.
culminated with the issuance of a warning. That is your contention.
Lordship, yes.
They could not have used it as a base for further proceeding further.
Lordship.
Okay, that's one. Then number two.
Lordship, number two is Lordship. Inquiry officer findings were proved except charge number 5. Disciplinary authority, Lordship, all the concurred with the findings of the inquiry officer. Now, Lordship, the appellate authority, if your Lordship kindly takes up the.
Inquiry officer had said what? Except one, rest not proved.
Rest are proved, Lordship.
Rest not proved.
Rest are proved, Lordship.
Rest are proved. One is not proved.
One is not.
Then?
Lordship, then disciplinary authority concurred with the findings of the inquiry officer. And the penalty of reduction in to lower stage in time scale of pay was imposed.
Okay.
Thereafter, Lordship, appeal was heard. That appellate order, if your Lordship kindly takes up the appellate order, Lordship.
What is
at
page
115. Lordship, therein the appellate authority came to a finding as regards.
You preferred an appeal.
I preferred an appeal, Lordship, against the penalty order. Appellate authority as regards the impressed case came to a finding that yes, though it was refunded subsequently, but that was a temporary misappropriation of public money. Charge was proved. As regards the second charge also, it stood proof. Third charge, Lordship, that was pertaining to, Lordship, some excess drawal on field trips in respect of me and the head
but
of.
Those were proved charges.
Lordship, yes.
So how does it make a difference whether the appellate authority had made some other observations?
Lordship, will kindly see the appellate authority in charge number 3, wherein some drawals were made.
Which charge was held to be not proved?
Lordship, charge number 5. There's
5. Has he altered the finding?
No.
So what has been proved? He has been isn't concurred. Maybe he has given some other reasons.
Lordship.
How does it materially change your case?
Lordship, as regards the charge number 3, the allegation was that the charge was that I had drawn some allowances, field allowances in respect of me and the head of Gabon, one Shri Vike Kulshrestha. Now, Lordship, the appellate authority stated that the excess drawals which were made by Vike Kulshrestha, I could not have been held guilty of that because I was not the head and therefore the policy may not have been in my notice. And Lordship, but accordingly, Lordship, Vike Kulshrestha, the person who had been the beneficiary of those allowances, no proceedings were drawn up against him. That was charge number 3. Charge number 4 was pertaining to Lordship, mobile roaming, which was used in India. The official mobile which was allotted to him in Gabon was used in India. Therein, Lordship, my contention was that as an emergency measure wherein my phone was not working, I had used that mobile in India and I was not aware of the policy. Charge number 4, the appellate authority states that the policy was there, therefore, since you did not know, that cannot be a ground. Charge number 3, Lordship, wherein the head was involved, therein appellate authority states that it's a policy, it may not have been in your notice, therefore you cannot be held liable. Charge number 4, he says the entirely opposite thing, that it's a policy, therefore ignorance of law cannot be taken as a excuse. Now,
Mr. Chakraborty, you assail the appellate authority's order if there is a difference in the finding,
Lordship,
which is prejudicial to you.
Lordship,
If there is a finding which was in favor of you by the
Lordship,
disciplinary authority, and that has been altered, then you make out, if there is a concurrence, maybe because of some other findings, that will not materially alter your this adjudication process.
Lordship,
You argue on those points.
Lordship,
If there is an alteration of a finding which was favorable to you, that has been altered without giving notice to you, then a prejudice case of prejudice may be made out.
Lordship.
Here, third, last leg is not required to be argued so far as we have understood.
Lordship.
You can argue on the first two.
Lordship.
There are how many charges were there?
Lordship, 5 charges. Lordship.
5 charges.
Lordship.
You said an explanation letter 25/7/12/2012 had ended with a warning. Which date?
Lordship, that is on Lordship 29/8/2012.
Would like to see the order.
Lordship, page 35, Lordship.
29/8/2012. 29/8.
Lordship.
After your reply?
After my reply.
You had filed a reply to the explanation?
Lordship.
Let's see.
Page 35 is the order, Lordship. Page 35, Lordship, 29/8/2012. In view of your acceptance of the contents of letter dated so and so,
and regret expressed by you, it is decided to record an official warning to you in this matter. Please acknowledge receipt of this letter. Now, this official warning was also included in my service record, Lordship.
And you said that it was also taken into consideration for your next promotion or something.
Lordship, yes. In the
What
year,
was- in
the year 2014, Lordship.
how was it acted upon?
Lordship.
How was it acted upon? You are not given a promotion or what?
Lordship, 2014, I was entitled to promotion on 1/7/2014 from to grade G. Lordship, that was not given. Memorandum was issued subsequently, Lordship. But the promotion which was already, memorandum was issued, Lordship, on 27/11/2014.
Okay.
And the promotion to grade G, I was entitled on, Lordship, 1/7/2014.
But it was nonetheless given effect to. This warning had adversely affected your career.
Lordship.
Okay, thereafter what happened?
Lordship,
In spite of this warning, there is a formal show cause.
Lordship, yes. Lordship,
Page
48, Lordship.
48.
48, Lordship. (27/11/2014) memorandum, Lordship. Lordship, the charges are at page 49, Lordship.
Memorandum of charges.
Lordship.
How many? 5 charges.
5 charges, Lordship. Page 49.
Page
49, Lordship.
49.
Lordship. May I read it, Lordship?
Yes, just a minute, please.
While posted and functioning as Chief Manager FNA in Gabon Project Gabon, during his tenure between the periods of 4/7/2011 to 11/6/2013, Shri Arun Kalita, this is the petitioner, Lordship, committed the following misconducts. Charge 1. Shri Arun Kalita misappropriated the impressed cash as well as the cash balance of the project for his own use to the extent of rupees 3 lakhs, showing the malified intent in misusing the fund of the company for his own benefit. Then, Lordship, charge number 2. Shri Kalita claimed foreign travel allowance wrongly for his favor, as well as for the favor of the then in charge of Gabon project, Shri V.K. Kulshrestha. Even after the same was pointed out by the internal audit, necessary corrective action was not taken to recover the excess amount from the salary of the respective executives. Charge 3, Lordship. Shri Kalita wrongly allowed Shri V.K. Kulshrestha to draw an excess foreign tour claim of $460, then the eligibility without any approval.
But these were not part of the original explanation.
No. Lordship, original explanation was only concerned to the amount of
So
impressed
these
cash.
are different independent charges. How will the warning be effective? Warning ended up, you may be correct in contending.
Lordship.
Warning ended up and has to be confined to the aspect of
impressed cash.
Lordship. The others are independent charges.
Lordship, other charges, your Lordship will kindly see the appellate. I will take your Lordship to the appellate.
No, but those are different matters, subsequent. But these at the outset,
Lordship.
Your submission may not be correct. These are independent charges.
Lordship, as regards 2, 3, 4, and 5, yes, those were not there in the first.
So your first submission will not hold good. We thought that we are trying to compare page 34 with page 49.
Lordship, that was only
except one, none are matching.
Lordship, except Lordship, yes. Impressed cash was only the allegation in the explanation.
Yes. So at least 4 of the charges are there.
Lordship. But your Lordship will kindly see that thereafter the appellate authority's order, I will take your Lordship, because the charge is this amounts, no necessary corrective measure was taken to recover the amounts. Appellate authority admits that these amounts were recovered. Lordship, appellate authority admits that these amounts were recovered.
First, you go to the inquiry. What is the wrong in the inquiry? What is the report of the inquiry? How was the inquiry report accepted by the disciplinary authority?
Lordship.
You cannot go to the appellate authority.
No.
You have to, the challenge has to be based on the procedures. You cannot infer something from what the appellate authority had done.
No, Lordship. I only stated about the appellate authority because this charge, wherein it was stated that it was not recovered,
We may not go into the merits of the charge.
Lordship.
You make out a case on procedural irregularities. We are acting as a secondary authority.
Lordship.
It's a disciplinary proceeding. Our hands are very tied. We're in a very limited scope. We are exercising our jurisdiction.
Lordship.
We are not entering into the merits.
Lordship.
Unless you, of course, make out a case of perverse appreciation.
Lordship. No, only on that perversity, because I will take your lordship to the
Hmm.
inquiry report. This recovery, what the inquiry report stated as that this was recovered subsequently. That has also been concurred by the appellate authority. That has been concurred, but the charge that it was not recovered stands falsified by the admission made by the appellate authority that those were actually.
But at the time of framing of the charge, was it recovered already?
Lordship, at the time of framing of the charge, it was.
It was already it stood recovered.
Recovered.
Let us see which one.
Lordship.
Which charge?
Lordship.
Charge number?
Charge number 2 and 3, Lordship.
2 and 3. Foreign
Foreign travel allowance.
It could not have been. Necessary corrective action was not taken to recover the excess amount. That is the charge.
Lordship.
Could not have been recovered if already recovered. This charge could not have been there. When was the recovery made?
The recovery was made. But the dates, unfortunately, are not.
If you don't have the dates, how do you make this contention?
Lordship.
That charge was framed which are factually incorrect. And that incorrectness would only be on the aspect of framing of the charge. It will not make the entire charge non-est. Charge will still be there.
Lordship.
Whether recovery was made or not, that's a different aspect.
If only the admission is there, but the exact date also is this. But that exact date when it was recovered is missing.
So what is your basis of your contention that the charge numbers 2 and 3 are factually incorrect?
Charge number 3.
Yes.
Charge number 3, Lordship, wherein the allegation was that VK Kulshreshtha, I had wrongly allowed VK Kulshreshtha to draw an excess foreign tour claim of USD 460. Lordship, that the appellate authority states that VK Kulshreshtha was entitled to that amount. The only thing is that, Lordship, the self-declaration forms were not submitted by him. The allegation was that, Lordship, Shri Kalita wrongly allowed VK Kulshreshtha to draw an excess foreign tour claim of USD 460, then the eligibility without any approval. Also, USD 600.
Now, has the appellate authority altered the findings?
Lordship, findings have not been altered.
If it's not altered, how does it help you?
Lordship,
Where are the findings?
Lordship, the effect.
What are you challenging? You are challenging the DP outcome and the appellate authority's order,
Lordship.
concurring with the DP.
Lordship.
And if you are if the appellate authority has concurred, then those are matters of challenge.
Lordship, charge 3, the appellate authority has deferred. Charge 3, Lordship, inquiry officer stated that it has been proved. Appellate authority states VK Kulshreshtha was entitled to that.
Let us see the finding of the appellate authority.
Lordship, that it starts from, Lordship, page.
So far as charge 3 is concerned,
Lordship, that is at page 119, Lordship.
119.
119, Lordship.
119.
Lordship. Down below, Lordship.
So far as 3 is concerned, you said out of 5 charges,
Lordship.
1 was held to be not proved.
Proved,
Which,
Lordship.
not proved.
Lordship, only 5 was held to be not proved. 1 to 4 were
No. One of the charges, not number 1.
Lordship, yes, one of the.
5th was held to be not proved.
Lordship.
Miscellaneous deduction
Lordship.
by the inquiry officer,
Lordship.
as well as the inquiry. That was okay. 5th charge held to be not proved. Appellate authority at page 121, no?
Yes.
Held. 3rd charge not proved.
Appellate authority, third charge.
3rd charge not proved. What about the 5th charge?
Lordship, 5th charge, Lordship, appellate authority concurred with the inquiry officer that since it was not proved, he is not going into that one, Lordship.
So you have 5 charges, out of which 2 are held to be not proved finally.
Lordship.
There are still 3 charges,
3 charges.
which stands proved.
Lordship.
So you need not concentrate on 3 and 5 and 3. You have to concentrate on 1, 2 and 4.
1, 2 and 4.
1, 2 and 4, what is the procedural irregularity?
Lordship, as regards charge 1, that relates to impressed cash.
Yes.
Lordship, there was a warning issued to
That one you have, and then so remaining is 2 and 4.
2 and 4, Lordship.
Yes.
Lordship, 2 and 4, if I may just read page 120 for a moment, Lordship.
Yes.
The second para, Lordship.
120.
Page 120, Lordship. The
120 second para is relating to 3rd charge.
On the other hand, Lordship.
That is relating to a 3rd charge.
3rd charge.
3rd charge is already gone.
Lordship, that might be relevant for charge 4 to an extent, Lordship.
What about 2?
Lordship, 2, the allegation, Lordship, that the only contention was that owing to foreign exchange, Lordship, fluctuation, that excess royal was, Lordship, that is amounting to around $91. Owing to that had occasion. That is the stand of the delinquent, Lordship, as regards charge 2.
No, 2, what is the, that explanation we are not too much concerned.
Lordship.
We are concerned with the procedural part, 2 and 4.
Lordship,
Two
procedure-
again, let us again read two and understand two at page 49.
Lordship,
You had claimed foreign travel allowance wrongly
Lordship.
in your favor as well as in favor of the then in charge of Gabon project so and so. Even after the same was pointed out by the internal audit, necessary corrective action was not taken to recover the excess amount from the salary of the respective executives. And four, you did not deduct from the salary towards the payables to the company, even though he had given undertaking to do so. So 2 and 4 are connected.
Lordship.
As per 2, you had claimed foreign travel allowance which was not due and therefore which was pointed out in the internal audit,
Lordship.
and you did not take any step to recover the excess. And 4 is that you had given undertaking, in spite of that you had not
Lordship.
made the payments.
Lordship.
So what are the findings and why these findings should be interfered with by this court?
Lordship. So that's the charge number 2. The inquiry report observations are at Lordship page 95. Inquiry report findings.
Yes.
May I read, Lordship? Page 95, Lordship. 5.2.1, Lordship. Both CEO and Shri KK Kulshrestha claimed DA on account of visit to operational area at $350 per day as against the entitlement of $20 per day, as per clause 2.11.13 of pay and allowances policy. This excess claim was paid by CEO as Chief Manager FNA. As endorsed on the body of the salary advice of so-and-so, CEO recovered an amount of 1558.163 as against the recoverable amount of $1650 from his own salary account of March 2012 as against the recoverable amount of 1650 with a short recovery of $91. Therefore, the amount which was allegedly excessively drawn, that was recovered, but with a shortage of $91, Lordship. Whereas in case of VK Kulshrestha, CEO recovered the full excess amount, claim amount of $3,300 from Shri Kulshrestha's salary account of March 2012, but added an additional amount of $600 to his salary. There was no noting or recording regarding the reason for the short recovery of $91.837 from CEO's salary, and also for adding $600 to VK Kulshrestha's salary for the salary of March 2012. It is alleged that the above indicated negligence on the part of CEO in short recovering $91.837 from his own salary, and that the CEO committed misconduct by adding $600 in the salary of VK Kulshrestha. Now, therefore, an amount was recovered, but yes, $91, there was a short recovery, Lordship. Now, Lordship,
And adding $600
to the account of VK Kulshrestha.
Oh, okay.
That your Lordship will kindly see. The $600 part, which is the allegation, your Lordship will see page 120.
120.
120. Because this $600 was also a part of the charge number 3, Lordship. Page 120, Lordship.
Yes, what
Page
is it?
120, Lordship.
Yes.
The second paragraph from the top, Lordship.
Yes.
On the other hand, with regard to the payment of $600 to Shri VK Kulshrestha towards miscellaneous expenditure, it is observed that Rule 2.11.9 of the policy for overseas posting provides for payment of $500 to the project head, out of which $100 is paid on self-declaration and remaining on submission of vouchers. Therefore, Shri Kulshreshtha was entitled to receive $100 per month on self-declaration. The prosecution produced such declaration for the month of June 2011, but it has been alleged that the CO paid the balance amount without any self-declaration. In this regard, I am of the view that the project head was entitled to receive the amount as per rule, and separate sanction is not required. Since CO was not in charge of the Gabon project and not in custody of the relevant official document, he cannot be made responsible for not producing the said self-declarations. Besides, prosecution could not substantiate conclusively that those self-declarations were not actually submitted. Nevertheless, even though the said payment was paid without self-declaration, but since there was no loss to the company, considering the fact that Shri Kulshreshtha was entitled for the amount, I am of the view that the CO should get the benefit of doubt. Now, Lordship, that 600.
Yes.
That $600, Lordship, under charge number 2, that the appellate authority says that he was entitled for the same, which was given to VK Kulshreshtha, adding to his salary account. The only thing is, Lordship, that the self-declarations which should have been submitted by Mr. Kulshreshtha was not submitted. But it's an admitted position that he was entitled to the said amount. Therefore, charge number 2 remains only to the extent of, Lordship, $91, the short recovery, Lordship.
Let us see the statement of allegation
Lordship.
of 2.
Lordship. What your Lordship will find at page
2 at page 50.
Lordship. May I read, Lordship? While posted in Gabon, Shri VK Kulshreshtha GM Gabon project and Shri Arun Kalita, the petitioner here in Lordship, had visited the field in various occasions and also claimed foreign DA for the same. As per policy of the company, the executive posted abroad are entitled to claim a DA of $20 per day for such visits. However, it is seen from the two claims of VK Kulshreshtha that he had claimed on 3 occasions.
This 600 allegation is a different charge. The appellate authority is finding on charge 3, you cannot take advantage so far as explaining charge 2.
No, your Lordship will kindly.
2, if you read the statement of allegation.
Lordship will see the next page, Lordship, page 51, which
Yes.
also pertains to charge
Yes.
2, Lordship. From your Lordship will kindly see 7th line, Lordship, in the middle. However,
Yes.
the reasons for short recovery, Lordship. Just below the
Yes,
table.
yes.
However, the reasons for short recovery of $91 from 8.837 from Shri Arun Kalita and the excess payment of $600 to Kulshreshtha was not clarified. Because the 600 were added. Also, the clarification was sought from head Gabon project with regard to addition of $600. While emailed at so and so, Shri S.C. Mishra clarified that there was no noting or recording made while adding $600 in the salary of VK Kulshreshtha. Next para, your Lordship will kindly see. So it is established that these were undue favors made by Shri Arun Kalita while dealing with the disbursement of salary and recovery of the dues. There was negligence on the part of Shri Arun Kalita in recovery of $91.837 from his own salary. And also, he committed misconduct by adding $600 to the salary of Shri VK Kulshreshtha.
Yes. But 3 is different then. What is the statement of allegation? 3, third charge held to be not proved.
Third charge held to be not proved, Lordship. As third charge, your lordship will see.
Okay, yes.
Lordship. Therefore, lordship, this allegation of $600, which was added to his salary, which the charge was that was not approved. Appellate authority says that he was entitled to that amount and no approval was required, but self-declarations were required to be submitted, which were not submitted by Shri Vijay Kulshrestha.
Yes.
Lordship, now, lordship, therefore, for one moment, lordship, the ultimate beneficiary, assuming, lordship, there was some irregular payment, was made to Vijay Kulshrestha. Now, lordship, there is no proceeding which has been drawn up against the person, Vijay Kulshrestha, assuming that it's an irregular payment. Though the appellate authority states that he was entitled.
Yes. Yes.
Lordship. Now, lordship, kindly see charge number 4, lordship.
Yes.
In the inquiry report, it is at page, lordship, 52, lordship. Page 52, lordship.
Yes.
It was mentioned, para 4, lordship, charge 4. It was mentioned by head Gabon project Shri S. Mishra in his email dated so and so that Gabon mobile numbers are not used in India due to high roaming charges. However, Shri Arun Kalita used the same during the period of 1/12/2012 to 31/12/2012. And the excess roaming charge was to the extent of FCMA 617927. Shri Arun Kalita had given an undertaking to recover this excess amount of FCFA so and so from his monthly salary of February 2013 to May 2013 as FCFA 154,482 per month. However, he did not deduct any amount in this regard from his monthly salary during the period. In the month of June 2013, he was transferred to India and it is understood that the amount was yet to be recovered till vigilance pointed out the same. Therefore, lordship, thereafter, after vigilance pointed out, it was recovered. From the above acts of Shri Arun Kalita, it is clearly established that he had taken advantage of his position not to deduct the outstanding company dues from his salary, and this amounts to his malafide intention. Lordship. Now, in this regard, lordship, the appellate authority also held that this charge stood proof, because my contention was that, lordship, I was not aware of any such policy, and the mobile which was used in India was as an emergency measure because there was some issues with my personal mobile phone.
Okay.
Now, as regards this one, lordship, the appellate authority held at page 121. It starts from page 120, lordship, down below. Page 120, lordship. May I read, lordship? Article charge 4.
Yes.
The allegation arises out of misuse of official mobile by CO allotted to use during overseas assignment, resulted in excess mobile charge of rupees 71,021 rupees on account of high roaming charge. It is an admitted position of CO that while on official off to India, CO used the official mobile on emergency situation as his local SIM was not working at the relevant point of time. Rule 2.11.8 of the policy governs that entitlement of official mobile to executive posted at overseas posting, which stipulates that mobile phone connection shall be provided by OIL for the official usage to officers posted overseas. Thus, it is clear that the mobile phone provided to executive can only be used for official usage. But admittedly, CO was not on official duty to India, and as such, he was not entitled to use the mobile phone while on visit to India. However, the submission of CO that he was not aware of company's rule and the mobile was used in the emergency situation was not found to be satisfactory and convincing, as ignorance of law cannot be an excuse. It is also observed that from the evidence on record that CO gave an undertaking to GM that excess roaming charges shall be deducted on installment from the salary for the months of February 2013 to May 2013, when CO was in charge of finance in the project. CO left Gabon project on transfer in the month of June 2013. And as admitted by CO in his explanation dated 26/5/2014, the recovery was not made during his tenure at Gabon. As evident from the exhibit P28, said amount was recovered from the salary of CO in the month of September 2018, along with other recoverable as per the advice of Vigilance Department. Hence, it is clear that the CO failed to deduct the excess amount from his salary in spite of giving undertaking in this regard. Therefore, I am in agreement with the findings of IA and the decision of DA, wherein CO was found guilty of the charge.
Okay.
Lordship, this observation, your Lordship, may kindly peruse in light of the observations at page 120 as regards charge number 3. Charge number 3, Lordship.
120.
Page 120, Lordship. Charge number, just above charge number 4, Lordship. It starts with sixth line, Lordship. Since the CO was not in charge. Since the CO was not in charge of Gabon project and not in custody of the relevant official document, he cannot be made responsible for not producing the self-declarations. Besides, prosecution could not substantiate conclusively those self-declarations were not actually submitted. Nevertheless, even though the said payment was paid without self-declaration, but since there was no loss to the company, considering the fact that Sri Kulshreshtha was entitled for the amount, I am of the view that CO should get the benefit of doubt. Now, as regards charge number 4, here, Lordship, the appellate authority states that since you were not aware of the policy and there was no actual loss to the company.
Charge number 4.
Charge number 3, Lordship.
3.
It states that since I was not aware of the policy and there was
No, it's not a question. That's not the finding. That finding of policy is of article number 4, charge number 4.
Lordship,
that you are not aware of the policy. That you was not excused. That excuse was not accepted by the
Lordship. But in charge number 3,
yes,
wherein the
that is not the finding.
Lordship,
Our finding is that CO was not in charge of the project and was not in custody of the relevant official document.
Lordship, yes.
That is not ignorance of policy. That's a different
Lordship, because
different aspect altogether.
Lordship, my submission is that, Lordship, because herein also, I was not in possession of the official documents in charge number 3, Lordship.
Yes.
Therefore, Lordship, benefit of doubt was granted and
how do you compare or relate this to these findings in charge number
Lordship,
4?
because charge number 4.
There is a policy you said that you are not aware of.
Lordship.
Can it be equated with something, a document was not in you are not officially in possession of a document?
No, Lordship, will see. Not in possession of the relevant official documents wherein it was stated that self-declarations were required.
Yes, that self-declaration has to be given by that Kulashestra. He has not given.
No, Lordship, yes. Lordship, under that policy,
No. Policy of using a mobile and policy of self-declaration, totally different things. You cannot equate those.
Lordship, my submission is that, Lordship.
You may say that is a too strict finding, but you cannot say that this is a very genuine kind of excuse.
Lordship, also as regards the second part, wherein it was stated that though the amounts were paid to Kulshreshtha without self-declaration, but since there was no actual loss caused to the company, Lordship, as regards my...
But there was another finding that Kulashestra was entitled to the amount.
Lordship, yes. Lordship, yes.
You are not entitled to use
Lordship,
a mobile of Gabon in India.
Lordship,
and in spite of your undertaking to replenish the loss, you had not done so. You had done it only in September 2014.
Lordship, wherein my only submission is that, Lordship, admitted, Lordship, it was recovered subsequently. But that aspect of loss to the company, temporarily...
See, if you are contending on loss, your position will not be, you will not be in a safe position. Even a loss of most temporary nature,
Lordship, yes.
but it has to be examined from the context of these facts and situations.
Lordship, yes.
Whether it was a misappropriation as per se, number one.
Lordship.
Number two, what was your intention? Was there any intention as such? You can argue on those aspects.
Lordship, the intention part, Lordship, your Lordship will kindly say, the allegation was that.
Okay, Mr. Sharma.
Lordship, and only one aspect.
Yes.
Lordship, after assuming for a moment, Lordship, this penalty order was issued in, Lordship, 19/11/2015.
19/11/2015 page?
Lordship, that is at page 102, Lordship.
102, penalty order.
Penalty order.
What was the penalty?
Lordship, reduction to a lower stage in time scale of pay.
Reduction to a lower stage
Lordship, yes.
in time scale.
Lordship.
Yes.
It starts from page 100 to the final operative portion is at page 104, Lordship.
Yes.
Now, Lordship, under the promotion policy of the Oil India Limited, if a major.
Are you in service?
No, Lordship, he has retired. He has superannuated from service, Lordship, in May 2020.
Yes.
Lordship, under the promotion policy, if any major penalty is issued against a employee, Lordship, 3 years thereafter, he is not entitled to promotion. Lordship, if I am entitled to promotion today, if a major penalty is issued to me in the preceding 3 years.
There is a cap of 3 years.
Cap of 3 years. Now, Lordship, this penalty order was issued on 19/11/2015. Therefore, Lordship, assuming for a moment that this penalty order was valid, sustainable, Lordship, it expired its sting on 18/11/2018. 3 years, Lordship.
Yes.
I was entitled for promotion to the grade G on 1/7/2014, which was denied for that warning which was recorded in my service book, Lordship. 1/7/2014, Lordship. That was my date of entitlement. That was denied, Lordship.
Entitled for?
To promotion to grade G, Lordship.
Grade G.
Lordship.
Okay.
Lordship, that was denied due to the warning which was recorded in my service book.
Yes.
Now, Lordship, be that as it may, if the penalty order was legally valid, Lordship, it expired its force on 18/11/2018. Now, Lordship, promotion was granted to the petitioner only in the month of January 2020.
January
2020, Lordship.
But was there a vacancy in 18/11 to how is the promotions? How are the promotions affected?
Lordship.
Is it a timely? Is it a secured promotion?
Lordship, it will be based on Lordship vacancy. Lordship,
No, not only vacancy. What about your
Lordship, yes.
Your
Entitlement.
performance?
Lordship, it was based upon. Lordship, that is a page. Page 124, Lordship. The promotion policy.
124.
124, Lordship. Lordship will see the fourth column, F to G, fourth row, Lordship. I was promoted to grade F on 1/5/2011.
1/5?
2011, Lordship.
Promoted to?
Grade F.
Grade F.
Lordship. Now, your Lordship will kindly see the fourth row from F to G.
Yes.
The residency period, Lordship, 3 years.
Yes.
Now, this 3 years, 1/5/2011, it completes in 2014, Lordship. Now, Lordship, the memorandum was issued subsequently, but this promotion was not granted as per my instruction based on that warning which was recorded.
Yes.
And therefore, Lordship, even assuming the penalty period to have been expired after 3 years, thereafter another 1 year, 4 months thereafter, this promotion was granted to me in January 2020.
You said that 3 years qualifying service is 3 years.
3 years.
To be eligible for further promotion to G.
Grade G, Lordship.
G. But it will depend on the first vacancy. Number two, what is the policy? 3 years is a qualifying period. That means you become eligible. Doesn't mean that you have to be promoted. Whether vacancy was there, number two, whether in the selection you had made yourself eligible for promotion. Whatever selection in the form of APR or the evaluation, whatever. That we do not know. But if it's a time-bound policy, that the moment you complete 3 years, then you are entitled, then the matter would have been different. Then we can ask Mr. Sharma what. That's all?
That's it.
Just to address the last argument.
Now, first, let us
Yes.
take a practical view of the situation. He is no longer in the,
2020, he has retired.
he is retired. So even if he gets something, it will be in the form of monetary benefit. Monetary benefit in his retirement dues are concerned. Or if we hold that the extreme case that the penalty order has to be set aside, then what will happen?
That reduction of 1 grade in time scale, that will have to be readjusted.
Yes, readjusted.
And accordingly, the monetary benefits that will accrue to him, therefore, will have to be paid to him. That
Yes.
would be the.
That is the consequence if we allow the petition.
Yes.
If we do not allow the petition on the first leg, second leg is that after 3 years, on completion of 3 years from the date of penalty, he becomes eligible to be considered for a promotion.
What your lawsuit has said.
Yes.
Vacancy as well as his other eligibilities are concerned,
Yes.
as well as the company's.
But did
policy.
you evaluate him?
But subject to correction, lordship, will that not be a subject matter of another petition regarding the promotion aspect? Because here what we are primarily concerned is regarding the legality of the departmental proceeding and the penalty. So in that aspect, I do not have my instructions. We very rarely subject for lawsuit.
No, but he has pleaded this.
He has a prayer to that extent.
He has
said that.
pleaded this.
Yes. But that aspect we have not covered.
Have you addressed? First, we do not know how is the pleadings placed presented before this court.
We have not addressed on the promotion aspect also. Our affidavit is primarily concerned with the legality
Penalty.
of the departmental proceeding.
Okay.
And my understanding would be this aspect of whether he will be entitled to promotion past this 3 years of that period will be a subject matter of another petition wherein he will have to bring in.
It
all
is a
his
fresh
contentions.
cause of action, if
Yes.
at all. That is what you are
You have
continuing.
to bring in his contentions and then I get a right to reply to that by presenting all the necessary documents that the company has at its disposal. So maybe therefore we thought that did not be.
Okay.
But
Okay.
if
On the
a lawsuit goes, I can file additional
on the
affidavit.
primary challenge.
Yes, on the primary challenge lawsuit, now let me take your lawsuit to first page 49 because lawsuit has seen the charge number 1. There is an argument regarding the charge number 1. Page 49.
49.
49 of the charge memo, the first charge. Sri Arun Kolita.
Yes.
May I read it?
Yes, please.
Sri Arun Kolita misappropriated the impress cash as well as the cash balance of the project for his own use to the extent of rupees 3 lakhs. 3 lakhs, yes.
Yes.
Showing the malafide intent in misusing the fund of the company for his own benefit. Now, this is one charge.
Yes.
Now, the petitioner wants to get rid of this charge by bringing in a contention that at 2012,
Yes.
during the operations of the Gabon project, his superior had raised a particular flag by calling an explanation letter.
Correct.
Now, because an explanation was called for and he gave a reply wherein he had admitted to the fact that yes, I have done it, but then I will recover or I will replenish whatever amount has been taken off of that particular impress cash fund.
Correct. Correct.
Based on that, a warning was given.
Yes.
Now, whether that will amount to a sort of a departmental proceeding being conducted under the rules that we have, disciplinary rules that we have, whether the process that would be otherwise contemplated to inquiry on that particular aspect, will the petitioner be absolved from that liability? That would be one aspect.
But you had acted upon the warning.
Lordship.
There are consequences also after the warning. He said that his promotion, his career was affected.
It is denied, Lordship. If your Lordship will therefore
No,
come to our
Mr.
affidavit,
Chakraborty has categorically said
but in our, he
that
has
in
not filed a reply.
2014,
One aspect, Lordship, he has not filed a reply to our affidavit. Therefore, what is sitting in our affidavit have to be deemed to be correct, if not factually incorrect. So therefore, if a Lordship will see,
let us see your averment, Mr. Chakraborty, that your promotion was denied in 2014.
this explanation cannot be equated
No,
to
just,
a
no, but if you have taken certain action of denying him promotion, let us see your averment. Which averment?
Not sure.
in our affidavit, paragraph 9, 15, 16, and 22.
Page?
Page 5. I apologize, Lordship, running is not
Doesn't
there.
matter.
Page 5, internal page 5, paragraph 9. 9, 15, 16, and 22, we have categorically dealt with this aspect, the charge number 1 and the warning, the issue of warning. Paragraph 9. May I read, Lordship?
You have said that, in fact, as per company's promotion policy 2012, a warning has no effect on his promotion.
Yes, we have categorically denied this aspect.
Not sure.
This was a warning during the course of operations at Gabon. The superior found something, he asked an explanation, he gave an explanation, and warning was issued at that point of time during the operations. And if you also see our disciplinary rules, therein in penalty, we don't have a penalty of warning. Our disciplinary rules, the penalties.
No, Mr. Chakraborty has not said warning per se as he has said it amounts to a censure.
But then my argument is that that could not be regarded as a disciplinary proceeding. It was only a sort of a operational, and during the time of operations, something was found and explanation was sought by his superior. And he was not the disciplinary authority also. In fact, after that, there was an internal audit. In the internal audit, all these things were found, the misappropriations. The petitioner was the chief manager finance, holding a very responsible position out there in Gabon. A lot of financial irregularities were found, and then this process of proceedings, tribunal proceedings was initiated. Regarding charge number 1, probably this explanation will not have the effect of absolving him from his liability of facing a departmental proceeding on that particular charge, which was ultimately found to be proved by the inquiry officer, because there is an admission on his part. And that temporary misappropriation remains. He gave loan out of that money. This is petty cash. Impress cash was petty cash, money that was in his hand. From that, he gave loans to other, personal loans to other. All have been recorded in the inquiry. He was using that money for his own advantage. When it was found, it was flagged. He said, I'm returning it back. So therefore, the intent of misappropriation till not found was probably there. When found, he reacted by saying, I'm returning it. And as an officer of such stature, as a chief manager finance, the trust that we have upon him was definitely dented. So this was regarding the charge number 1, that this particular explanation and the warning, therefore, will not absolve him from the liabilities of facing a departmental proceeding. And now regarding the other charges, if your lordship will come to the charge number 2, lordship has seen already the inquiry report at page 95.
What is second charge? Travel,
charge, yes.
travel allowance.
Sri Kolita claimed foreign travel allowance for himself as well for one Mr. V.K. Kulusetha.
Yes.
Now, regarding this, lordship has seen at page 95 of the inquiry. The charge was found to be proved to the extent that there was a short recovery of 91. So the fact remains that the excess payment was made. When found, recovery was done, or recovery was, the petitioner has returned the money, but still that amount was there, 91 rupees 91, no, $91. And regarding Sri Kulusetra's that 300 rupees, 600 USD, that amount is a different amount. If a lordship will see the page 51, the statement of imputation.
That was what we are trying to understand.
The USD
Only,
600.
only whether the digits are the same or the charge is the same.
No, the digits are same, but the charge is different. Because charge number 3, yes, the appellate authority has said that because the self-declaration was not given, but though he was entitled and there is no loss to the company, benefit of doubt is given to him. I will not argue on that aspect. But charge number 2, insofar as the foreign travel allowances that Mr. Kolita claimed, that is a clear finding. There is no objection forthcoming from the petitioner side also. His only argument is that I had returned, but the 91 US dollar, there is no answer to that. And regarding what was paid to Kulusetra, that you also will find at page 51, the imputation of charge.
Yes.
Just below the table.
Yes.
I'm just reading it from however, from between however. Also, you seen that?
The reasons. How about the reasons of short
Yes,
recovery?
however, the reasons.
That is okay for, that is for the petitioner.
Yes, I'm just continuing.
And
now,
the excess.
Reasons for short recovery of so-and-so from Arun Kulit and the excess payment of USD 600 to Sri Kulusetra was not clarified. Now, this is a separate incident. Also, clarifications were sought from head Gabon so-and-so with regard to the addition of rupees 600. There is one excess payment of salary. There is one aspect, and there is one another addition of USD 600. There are two that you'll also will find in page 95 also. 95 there was a recovery done from Kulusetra, but then he added another rupees 600.
$600.
Rupees comes out from amount. If you'll also will see page 95. Page 95 inquiry. This digit is same. The transactions are different. Subject to correction, however, also. What I have been able to understand. Page 95, clause 5.2.1. Clause 5.2.1.
Yes.
Both the charged officer and Sri K.K. Kulusetra claim dearness allowance on account of visit to operational area at the rate USD 350.
This will be daily allowance.
Daily allowance at the rate of USD 350 as against the entitlement of USD 20 per day as per clause 2.11.13 of the pay and allowance policy. There is a policy. In the policy, this clause categorically states that per day your allowance is only $20. Now here they were claiming and they were deducting USD 350. Senior officials dealing with finance. This was what they were doing. That policy also we have. The next. If a logic will say page 46, the policy is attached here.
Okay, doesn't matter then.
Yes, sir.
$20 was the daily allowance. 350 was claimed.
Was claimed.
Thereafter?
Not even claimed, it was taken in their accounts.
Okay.
Thereafter, if your lordship will come, I'm just reading further, lordship. This excess claim was paid by the CO as Chief Manager FNA as endorsed on the body of the salary advice of March 2012. CO recovered USD 1558 as against a recoverable amount of USD 1650 from loan salary account of March 2012 with short recovery of USD 91.837. Whereas in case of Sri B.K. Kulusetra, CO recovered the full excess claim amount of USD 3300 from Sri Kulusetra's salary on account of March 2012, but added an additional amount of USD 600 to his salary. There was nothing, there was no noting or recording regarding the reason for the short recovery of USD so and so from the CEO's salary, and also the adding of the USD 600 to Sri VK Kulachetra's salary of March 2012. Though there was a recovery pursuant to it being found, there was an adding of rupees 600, this USD 600.
I think there will be some connection. The allegation was on the aspect of daily allowance. Daily allowance for him while he had made the recovery, means paid back, not recovery. There was a shortage of 91 something. For Kulashestra, he has recovered the entire amount, but he has paid an additional 600. And this 600 comes under charge 3. This is the 600.
Also 600.
600, this is not, this is the same transaction, additional. And appellate authority had held that otherwise also Kulashestra was entitled to $600.
Subject to self-declaration.
Self-declaration not made. That can be a trivial kind of a procedure.
But that is also attributable to him.
Yes.
That's
And $91 is short. One, of course, you have made your submission that that warning will not absolve the petitioner, and the aspect of leveling the charge had not culminated with imposition of a warning as a penalty. That is not a penalty. That one superior officer had made some warning, but it a formal charge was leveled only with the memorandum of charge on 27/11/14.
Which was ultimately found to be proved by the inquiry officer. That misappropriation of 3 lakhs rupees, this is rupees 3 lakhs, yes, rupees 3 lakhs, that has been proved. And there is no counter against that. Barring the counter, that already.
But Mr. Sharma,
yes,
this explanation was called for in 2012.
Yes, boss.
He was given the official warning in August 2012.
Yes, boss.
And after 2 years, you make that also one of the charges.
Because the issue was, if your lordship will come to page 36, there
Yes.
was a vigilance report in May 19, 2014, wherein all these misappropriations were flagged, were found. Because this is a project happening in the international operations of in Gabon. So probably that access, that immediate access to certain things was not there. When this entire vigilance report was drawn up, then it was found that there was serious financial mismanagement happening, which led to the issuance of the show cause, lordship. Yes, there may be some time gap or time lag. That is true, that I admit. But lordship will also have to appreciate the fact that this was something happening.
What about
in
four?
a
What
overseas
about
operations?
what about 4
Yes, lordship. 4
remaining?
Yes, lordship. Sri Arun Kolina did not deduct from his salary towards the payables to the company, even though he had given other people. So now the payables here is regarding the telephone, the phone that been used, the mobile phone that was used. There, if your lordship will come to his reply, this payable is basically regarding that use of that SIM card, the Indian SIM card at Gabon.
No, Gabon SIM card.
In India, sorry. Yes, lordship. There, if your lordship will come to his reply at page 56. Your lordship will come to page 58. Page 58.4 of his reply. 8.4.
Yes.
Roaming charges. Because the loss was of the roaming charges. An
Yes.
amount of rupees 71,021.96 has been debited to my personal account and now been recovered from my salary. This is the only statement that he makes. The argument that is coming today, that he did not knew about the policy and all, was not what he has stated. He gave sort of a bold kind of a reply saying, it has been now recovered from my salary. So the issue is not whether it has been recovered or not. The issue is whether there was some sort of an intention for you to defraud the company at that point of time for your advantage. If which otherwise would not have been found, probably would have gone unnoticed to his advantage. So therefore, whether there was a misconduct or not is the issue, a pertinent question that has to be looked into. And in my humble submission, there is pertinent misconduct on this part because he holds a very important position in the company. When the chief manager finance, he was holding a post of utmost trust that the company was reposing upon him. And if he does this kind of activities, which only when it was found out, his only, Lordship, you will find his only contention is that I have returned it back. But returning of the back
No,
happened.
returning will not be of much of a relevance
Yes,
in
but-
this matter. But we have to see the intention. What is the finding? Finding is that he was not aware of.
Finding was that his statement is, in the proceedings, his statement is, I was not aware of the policy. But in his reply, he does not say so. Lordship will have to see the first his reply. The reply is, he says
See, ultimately, it's a use of a mobile phone which was SIM of a foreign country, for which there was roaming charge, and which was deducted, and ultimately, when it was detected, it was recovered from him.
Yes.
The use of foreign SIM at Indian soil entailing roaming charge, that is the allegation.
That is the allegation because as per our policy, that could not have been done, which he has did. And now the ground that is taken is ignorance of the policy. So that the charge is that we have a policy in place which says that you cannot use a phone or a SIM of that nature.
Understood.
He has used it and now he says that I am not aware of the policy. So therefore, as per our rules, it is a misconduct. So in my humble submission, therefore, there is no infirmity in the proceedings or in the process of the proceedings. The allegations were serious, allegations were proved. The person against which the DP was drawn was a responsible person of finance department, and therefore it has to be looked into with utmost seriousness. And therefore this should not be, the penalty does not deserve to be interpreted by the honorable court. Again. Procedure wise, any allegations of natural justice being violated or anything is not made.
Okay, sir.
And there was no reply to our affidavit filed by the petitioner. So therefore, our stands have remained uncontroverted in our affidavit.
What is your age, Mr. Chakraborty?
Lordship,
When
right,
did you retire?
2020, Lordship.
20.
66 approximately.
Okay. Okay, let us consider.
The policy is a pay 44.
Which policy?
That pay and allowances policies for foreign assignments is 44. But in lawsuit, will find that USD $20 and the other aspects. Annexed by the petitioner in his petition.
We'll reserve it for judgment, we'll consider, okay. Heard. Sri T. Chakraborty.
A Chakraborty.
A. Chakraborty. A. Chakraborty, learned counsel for the petitioner. Also heard Sri A. Sharma, learned counsel for the IOC.
All India, Standing Council, All India Limited.
Standing counsel, All India Limited.
Respondent 1, 2, and 3. There's a private respondent also.
Who?
His superior in Gabon, Mr. Respondent number 4. I think no one is appearing for him. The officer who had issued that explanation. Respondent number 4.
Just a minute. There's no finding with respondent 4. Doesn't matter at 2016 matter. Hearing is concluded, judgment is reserved. Okay.
And also one more aspect, at page 35 of our affidavit, the last page of our affidavit, his admission is there, the admission letter of this.
So far as?
So far as charge number, that impress cash is concerned.
Impress has admitted, that is there.
Admitted, this is the admission letter, just to point that out.
This admission letter is with relation to the explanation letter which was called, not subsequent to the memorandum.
Okay.
But the issue remains, the same issue.
Okay.
Obliged.
Obliged.
Yes, Mr. Poddar, you were waiting for a long, which matter? You may not have the, what, you're there.
Yes.
Next is this item number, come on with you. It's 23. What is the matter about?
Lordship, this is a dismissal of service. I am appointed as a cook. After serving of 10 years.
You are a bad cook.
That's my
That is why you say you have been dismissed.
Lordship.
You put too much of masalas. Your owner has fallen sick because of the masalas and spices. Proceeding was there.
Proceeding was there, Lordship.
What are the charges?
Charges only because I have a timeout pass. I went to Malbazar for 3 hours, one for 1 AM to 4 PM.
In the center,
So there is a delay in return.
Where in discipline force?
Discipline force, Lordship. SSB, Sashastra Sima Bal, Lordship.
That is the lone incident, sole incident.
That is the one incident. I have returned late. Then I was kept in prison. Charge was that I have broken the net of the prison and used some harsh words against the commander. That these 3 charges are there only. And I have dismissed from the service.
How is this performance as a cook? Madam? You are satisfied with his cooking? Huh? You don't think so? If you are satisfied with his cooking, why should you dismiss him? Utilize his services. But today will not be possible. We have to write, before the vacation, we have to write the judgments. We'll have it some other day.
Monday
may not be, Tuesday we'll try.
Tuesday, Lordship.
Tuesday we'll finish this up.
Lordship.
Pleadings are otherwise over? Pleadings have been completed?
Yeah, completed.
You have the records also. On what grounds are you challenging, Mr. Poddar?
Entire proceeding, the procedure they have followed is proper, Lordship. Then I have preferred the appeal, and the first word of the appeal is that I have pleaded guilty.
Oh.
That is not at all, Lordship.
The proceedings were have been recorded in which language?
The English, Lordship.
Okay, you understand English?
No.
You have been given a defense representative.
They have given a defense counsel, defense
representative.
But I am not on that part. Up to that part, okay.
Okay.
But
you have never pleaded guilty as such.
Not at all, Lordship. Even my appeal memo is clear, Lordship.
Okay, let us see. Mr. Chakraborty, which matter?
Item number 27,
Along with whom?
Mr. B.K. Singh,
Okay. FCA matter.
FCM.
We'll have some other day. Today is not.
My lord, after vacation, my lord.
Okay, 27 after vacation delivery. Madam Singh, with Mr. You're with Mr. Singh? After vacation, any objection? Okay, after vacation delivery. We'll give a date. Others will give dates.
Item number 24 and 25, my lord.
Yes, what are the matters?
Dismissal from service, SSB, my lord.
SSB.
My lord, Tuesday, my lord.
Tuesday may not be, we have already fixed on, try on Wednesday.
My lord.
Subject to what, the next week has been declared to be motion days.
My lord.
But still then, if we have the time, we'll try to have the matter.
My
Okay?
lord.
You are in this Mr. Padgil's case? Okay. It Wednesday kori dibo, huh? Aru eta tomorrow too. Your matter, when? After vacation. Can be.